Was it 20? I think it was 22 just now.
You turned it up, didn't you?
Yeah, it's only on 21 now.
Because it's 22 feels like 17.
Yeah, you look like you're ready to go. Right, okay, so back in the room at 12:47. Okay, so chapter 2, criminal procedure in all courts. As I think I said this morning, there is some duplication, so there'll be bits that we can just kind of gloss over, I think, just speed through in chapter 2. So this is 2.1, the first instance courts. We've basically dealt with all of that, so I don't think there's anything to say there, except perhaps just that last couple of sentences. Committal proceedings said maybe old style of witnesses being called on new style of witness statements taking the place of live oral evidence. Most criminals now are new style and short hearings. I think Mark was saying yesterday, if you have a view on this, Catherine, Mark was saying he can't remember any old style committals taking place, and not for many years anyway.
I can remember. I can remember, but it's for all the reasons that you give later in the guide. That if you have an old style committal, you effectively give your case away. And why would you do that? You would only do an old style committal if you had an absolute bomb-proof way of getting rid of the case, because it can be regenerated in another form, even if you get rid of it at committal. So there's no benefit to it. I mean, I have a quasi old style committal that are there are many ones that are recently because we were unsure exactly what the prosecutor was getting at. Because when you get committal cases, you don't get anything on that line. I don't know if that's the same in England. You get no outline, you get the little papers which are trials of random exhibits and mistakes. And we wanted to pinpoint on what evidence he was relying for each and every element. And these money laundering offences, you know, very alarming with else, and you consider in that place and these states and all so we managed to go through the whole of it. We didn't ask, we made a submission, but we didn't ask any questions of how many witnesses thought it. We did that because we wanted to thought like even more detail. If that's unusual, I mean, I can't remember. The last old style committal I would have been aware of would have been in the early 90s. Yeah.
Okay, thank you for that. All right, 2.2, I don't think we need to worry ourselves with because it's repeating points that we looked at this morning. Likewise, 2.3. 2.4, right of appeal, I think we covered that this morning. 2.5, I don't think there's anything else. So really, we might just kick off with 2.6. Yeah, sorry, no, yeah.
So, if you Google Guernsey decision get this code, I have to say that as practitioners, we didn't know it was there until some point last year. I had a client who pointed out it was there, and quite recently, someone who was in the criminal team also disclosed not being aware that it was there. So whilst I'm sure they're using it, and it's very heavily, people didn't actually know it's there.
Oh, is that reassuring? I feel like crying at this moment, but anyway, I'm not going to. Right. Yeah, brilliant. So, all right, yes. Well, on that point, at the bottom of page 30 and page 31, you'll see it says see code of guidance, or there is a supplemental code of guidance for reviewing domestic violence cases, and those underlined references there should be hyperlinks. Okay, well, they were hyperlinks when I made them, but they don't work. Okay. So this is indeed the website to which Catherine has just referred. And as you can see, it's Guernsey Law Officers, all one word, .gg. If you just type that in, then you go to the previous page, but it's very easy to find from their decision to prosecute. And you can see there you've got access to the decision to prosecute itself, code of guidance, and also to the supplemental domestic violence code of guidance down there as well. So yeah, I mean, it might be something you could refer your prosecutor to, or perhaps refer the court to. Maybe on, I don't know, maybe on an abusive process application. Yeah. But anyway, so you can find them. They're very easy to find, even if the law officers haven't.
I think they're, to be fair, I'm sure that they've been applying, and I think they're just surprised to find it in the public.
Yeah. Well, I mean, even that's interesting, because I mean the Crown Prosecution Service in England and Wales, I mean, they've got their website, and the equivalent has been up there for donkey's years for people to look at. If they can find it amongst the morass of crap that is on the CPS website.
It is a useful website, though, the CPS one.
Yeah.
As is the judicial one from what it's called now. But that's
Judicial College?
The one that gives all the directions.
Well, I think it's Judicial College. It has the Crown Court Compendium.
Yeah.
Yeah.
That's very useful, some of the directions.
Yes. Yeah.
Not for the exams, but for practice.
Yeah, and I also think that for, well, again, it's different things, but if you are having issues kind of getting your head around maybe particular principles of evidence, because the Crown Court Compendium tells judges how they should explain these principles to juries, it tends to have quite a nice, clear kind of thought process working your way through. So I just mentioned that in passing. Obviously, a lot of the principles that are there don't translate directly across. All right, okay, so decisions to prosecute. As it says there, the ultimate responsibility rests with the law officers. Prosecutions are brought in their name, certainly public prosecutions are brought within their name, and you have this entity called the Criminal Prosecution Directorate. What do we need to think about? Both those who are qualified as Guernsey advocates and those who are not work within the CPD. Excitingly, non-advocates may be appointed as special constables and will then have both limited rights of audience and the ability to prosecute matters in the magistrates' court. So that's quite interesting. 2.7, all the usual things you'd expect to apply to prosecutors being there. So it must be independent, must be objective, resist, as it says, undue, I'm not sure, undue pressure, any pressure really, resist pressure. Act in the interest of justice, not solely for the purpose of obtaining a conviction. But it always says that, anything you read about prosecutors, it always says that. I'm not sure how compatible that is with reality. You know, if you have a kind of like 0 from 12 record in your recent prosecution history, I'm not sure how all that goes down at your annual appraisal meeting, but you know, we're doing our job. We're not there to get convictions. Well, clearly I'm not there to get convictions because I haven't got any. So doing a good job, boss. Don't fire me. Anyway, as it says, decisions must be made on the merits in each case. That's something that the code points out. But as it says there, notwithstanding the independence, and this is an interesting, I think almost an ethical point for prosecutors, so it probably doesn't apply to anybody in this room, but as it says, growing trend for prosecutors where appropriate to meet victims or their immediate family, doing communication, although it says less serious cases that will normally be undertaken through a police officer rather than a prosecutor. And personally, I would just express the view that that's probably, frankly, seen as more appropriate in terms of saying that the prosecutor is there to be independent and free from external pressure, not there to seek conviction. The greater the interaction with the, I'm going to say complainant, because I'm not a big fan of talking about people as victims until we can actually establish there's been an offence through a verdict. But anyway, the more interaction you have between a prosecutor and a complainant, the more it looks like, and the more it's going to appear to the complainant that they are there for them, when there's a bigger picture that they're supposed to be looking at. So, yeah, they're not meant to be partisan, I think is the key point there, really. All right, advice, 2.8. So if you read the Code of Guidance, and it's not a very long document, so might be worth having a look at that. As you can see, prosecutors can advise investigators whilst the investigation is ongoing about possible lines of crime. So, things that you might want to have a look at, that type of thing. As it says, to establish whether an offence has been committed at all, and do we have any evidence to back it up in terms of a charge. So, as you can see there, the prosecutor could be advising on what evidence is necessary or desirable. Bear in mind that, generally speaking, of course, the prosecution bears the legal burden of proving any issues in any subsequent proceedings, and might offer an opinion in terms of likely admissibility in evidence in subsequent criminal proceedings. That's the sort of job, if you remember, Mark was talking yesterday about the Curtis Warren case in Jersey, where a Crown advocate there was engaging with the investigating police officers in terms of drug deals taking place, and police officers were seeking advice. I think they were seeking advice rather than him being proactive and offering advice in terms of the, should we say, practicalities, legal and otherwise, of attaching a bugging device to a vehicle on French soil without either notifying or getting the approval of French authorities, as far as that's concerned. So obviously that turned out not very well as far as if you like, judicial approval of that interaction and the advice that was given. Although ultimately, I suppose you could argue that, in a sense, although none of the courts involved in the Warren case said this, the reality is that the end justified the means, because proceedings were, anyway, yeah.
Well, of course, in that case, it went in, even though the police officers lied and cheated and behaved disrespectfully, we had to take them back to the beginning of the exercise and say, no. So when you start back again, because that's not a test. Doesn't matter what happens. I mean, the other thing is that the first time they take particularly interesting criminal. So there's some proportionality in that.
Yeah, he was a very serious player, wasn't he?
It was very serious offence, but yeah.
Okay. All right, so as it says there, important to remember that the CPD is an independent entity. Prosecutors are not intended to be investigators, so they will quite often come in to review what's actually gone on, and it may well be the case that the police refer a matter to the CPD for a decision to be taken about whether to prosecute, and if so, for what. So as it says, prosecution and police liaise frequently, and that review process quite often it is undertaken, or it's initiated earlier before we've even got to making a decision about charge. 2.9, in terms of attaching legal professional privilege to that sort of advice, those types of discussions, it says highly desirable that a full and frank discussion is undertaken, unhindered by the possibility that the contents might have to be disclosed to the defence in any subsequent criminal proceedings. So should be protected by confidentiality, and you've got that reference to the Taylor case at first instance, paragraph 19. I don't think that's one of the ones that I've got there. No, that's that one. No, I haven't brought that up. But anyway, yeah, Taylor at first instance explores that point. I think Taylor was, if he serves me correctly, was should we say, a rather trying case where the defence was suggesting, I think this is the right one, defence was suggesting that in terms of disclosure, the prosecutor had been, as they might say, economical with the actuality, and disclosed everything that might be disclosable, notwithstanding her assertion that she had applied the correct tests and done everything she should have done. And the court there was very critical of the defence advocate for making what it said were entirely unjustified comments or criticisms and assertions against the prosecutor. So yeah, generally speaking, obviously, if you thought that these discussions were going to be disclosable, that would be likely to have a chilling effect, which would mean they weren't going to be as effective as they ought to be. So generally speaking, should not be amongst the material that would be disclosed by the prosecution. Yeah, also picked up by the Court of Appeal in the same case later. You can see that in the second footnote there. So review, already really thought about that, and 2.11 makes the point that prosecutor will apply the prosecution test, which, just like the Code for Crown Prosecutors, if you've ever studied that in England and Wales, has two elements to it: an evidential test and a public interest test, and it needs to pass both of those hurdles in order to go ahead. So you can see then, is there sufficient admissible evidence to show a realistic prospect of conviction against every defendant involved on everything, every offence that they're charged with? So it says realistic prospect means that the court probably directed it more likely than not to convict the defendant. So not to be confused with the standard of proof, criminal standard of proof, which would of course either be beyond a reasonable doubt or satisfied so that you're sure. So it's a realistic prospect, more likely than not. I don't think there's anything in particular from that list in 213 I need to pull out there. But 214 makes the, I think, fairly self-evident point that if a prosecutor considers that the evidential test hasn't been met, so that there's no realistic prospect of conviction, the matter should stop there. Okay. Now, that's not kind of a full stop. It might just be we need to suspend it for the time being and continue or resume the investigative stage proceedings to see whether either more evidence can be generated or put into an admissible form, for example. So it could always come back again, but as it says, it's only if the evidential test is met that you move on to, if you like, phase 2, which is the public interest test there. And as you can see then, more serious the allegations or the more serious criminal record the defendant has, which gets us back to Mr. Warren, again, more likely it is the prosecutor will consider that the public interest is in favour of proceeding. Yeah. So as it says, weight of different factors should be considered, and a single weighty factor may displace several slim ones to the contrary. And you've got an example or a set of examples in 2.16 about the sort of points that the prosecutor would look at in making this determination about whether it's in the public interest. And again, towards the end of 2.16, you can see a reference there to maybe that the prosecutor considers that the matter can be more satisfactorily resolved through the administration of a full proportion. It may even be that if we're looking at a juvenile, that the decision is send it to the convener for action, maybe with a reference to the CYCT and into, so basically a diversion away from the criminal justice system. There is a third possibility, which is in urgent cases, this abbreviated evidential test. As you can see, that may be something that's initiated where the investigative stage is not yet thought to be complete, but there are concerns either that the defendant may commit further offences, which in itself almost involves a judgment about the evidence that you've got there, or as a flight risk. As it says, in that situation, it may be that the prosecutor feels and the police feel that a decision on charge, yes or no, needs to be expedited so that you've got some basis to hold on to the defendant, put them into custody and keep them there. So as it says, if the abbreviated test is satisfied, then there will be a charge and the defendant will be remanded in custody, subject to, obviously, to judicial review or appeal to the court as far as that's concerned. So you've got that set out there. And this is 2.18, because of the concerns around offending or absconding, there must also be substantial grounds to object to any release on bail and consider that an application to withhold bail may properly be made. So there's an obvious intersection there between the charging decision and the test that's going to be applied there and concerns around bail versus custody as well. Okay.
I mean, don't forget it was in practice as a defence advocate. you can always ask the prosecution to review its decision at any point. It's not uncommon in those really difficult cases where you've got a very vulnerable defendant or particular family circumstances, serious illness and the like, that you would know that you'd write to the prosecutor and say, look, please review this decision to prosecute because why is there any other? And that's where actually having this code and being able to compare and contrast and go through the exercise is a very useful one. And the prosecutors, I would say, are always willing to consider reviewing a case in circumstances. It's always worth a go. If there are extenuating circumstances, particularly if you think that the prosecution may not be aware of them.
Yeah, but I think on that point, yes, being familiar with what the code actually says is important, because then when you have that conversation with the prosecutor, you know that you're talking to them in the language that they're thinking about the case. You know, you're applying their considerations, their factors. So apart from anything else, if they then have to go back and justify it to superior, they know that they would feel safe from they're using the language of their own code, their own guidance. Yeah. Right. So charge selection, I think there's not really much to say there. It should be, as it says, it should reflect the seriousness and extent of the criminal activity and provide adequate sentencing powers. All right, so please, 2.20. If the case has been dealt with summarily, the defendant may ask for charges to be put. So he's asked to plead at the first court appearance, and indeed that may be an expectation from the court. Gets you into thinking about what reduced sentence for a guilty plea, timely plea of guilty. So your first opportunity, when's your first opportunity, practically, to enter a plea of guilty? If you kind of initiated or instigated that process, you've got a fairly solid foundation for arguing that you should get the maximum credit for that guilty plea. You certainly haven't sought to hold things up or cause any trauma for anybody there. As it says, alternatively, on the other hand, you may want to get legal advice and therefore ask for the matter to be adjourned in order to obtain that advice before you enter a plea. And that would be a reasonable thing to request. So if it says adjournment for 1 or 2 weeks to obtain that advice, likely to be granted. But if he's been charged several weeks before he's come to court, released on bail, charged released on bail, then as it says, the judge may query why that legal advice has not already been sought. Don't know why that equals sign has appeared in there, so get rid of that when we revise it. It says at 221, if the matter is going to be committed to the Royal Court for trial there, pleas won't be sought until the first appearance at the PDH, Plea Directions Hearing, in the Royal Court. And it's just a simple point with the greffier or the deputy greffier reading out the charge and then asking to the defendant, how do you plead, guilty or not guilty? Now 2.22, maybe Catherine can help me out with this. I've written there that it seems to be a simple binary choice between guilty and not guilty. Things that are referred to in England and Wales as special pleas, like ultra fire, acquit and convict. I haven't found any examples of those in any reported cases or anything to suggest that they have an equivalent in this jurisdiction. But I mean, presumably you would be able to raise an argument against double jeopardy to say,
yes.
yeah, without it necessarily being perhaps couched in that precise terminology. Yeah. So yeah, abuse of process would be a legitimate point to raise if you've already been convicted of an offence and you think that someone's having another go at you for exactly the same thing, not the same thing in different facts, but exactly the same thing. Then I think you could probably run that as an abuse of process argument. So as it says, it's not unknown for defence to offer equivocal pleas, by which they might say, yes, well, I'm guilty. As it says, I did stab him. I had no choice because he was coming at me with a pool cue. If it's not clearly one or the other, guilty or not guilty, the court should make further inquiries and try to do its best to resolve that. If it's, for whatever reason, it feels unable to resolve that with the necessary degree of clarity, then it's going to assume a plea of not guilty and proceed on that basis.
And the court is also sometimes faced with that, even when people are represented. And it happens in the Royal Court. and the magistrates court, it's happened to me in the Royal Court, where the client entered a plea of guilty, but when he went to the probation service for his inquiry, he watered down so far what he accepted as having done wrong, that when the probation report went through to the judge, somebody feeling to have a conversation about whether it was a. And so it's something that you have to talk to people, and I have talked about it, but it's something that you have to talk to people about. You can't plead guilty and then go on to probation service and say, how did I do wrong? It's a very critical thing, because then it's an equivocal plea and it's not what you try, and then of course you've lost your discipline. That's the thing.
Well, you can't blame them for trying, can you?
I'm not being told what to do.
Well, as long as you've got that on the record, that's important. Yeah. All right, multiple charges. I mean, in a sense, multiple charges in 223 kind of intersects with 219 in charge selection. Yeah. So shouldn't face multiple charges if the overriding motive is simply to place some pressure on them to plead guilty to what? The lower end ones, or a sample of them. Yeah, so I think that again is fairly self-evident. So we'll move on from that, as it says in 224. If the defendant wishes to plead guilty to everything they've been charged with, there's no trial. I never met a prosecutor that wasn't happy with that situation. But problems arise where they only want to plead guilty to some or to a less serious version, because then the prosecutor does need to make a decision. As it says there, should only agree to proceed with the proffered guilty plea. So there's a kind of an element of plea bargaining going on there. Should only agree to proceed with the proffered guilty pleas where they are content that those fairly represent the seriousness of the criminal conduct. Court retains adequate powers to sentence. Interested complainant not being adversely affected. And again, that is taking you back into exactly the same sort of considerations that the prosecutor would have had initially when determining what the offence would be that would be charged against the defendant. Yeah. So there's an element of kind of repetition of the thought process going on there. Let me see, 225, 226 is really talking about Newton hearings, and we briefly looked at that this morning. We're going to come back and look at it again next time when we move on to chapter 5 and think about sentencing. So I don't know that there's a great deal that we need to delve into here. You have an example there of where, in the case of Allen, where there was a Newton hearing. Basically, it was a straightforward credibility battle between the victim of an assault and the person that was pleading guilty to the assault. And I think put the important things. In fact, this is the case here, but I don't think there's anything in there that really adds anything to what you've got at 226. But you can see no dispute that the learned magistrate correctly set out her task in a Newton hearing type of case and approached it accordingly. What she actually had said was that she was satisfied that neither Miss Vaughan, who was the victim here, nor Mr. Allen, who was the defendant, told me a complete or correct version of events. I suspect this is for reasons, I think we missed out the word "to" in there. But anyway, yeah. Firstly, it was an extremely violent incident over some minutes, and it would have been very difficult for either to recall particularly the sequence of events that occurred. Okay? And secondly, to different degrees, both were not telling me the full truth, albeit for different reasons. Okay, so that's the kind of relevant part from the hearing, the Newton hearing, as far as the case of Allen is concerned. There are other points that lead on from that. Again, in terms of things like grounds for appealing, the reasoning that needs to be advanced in terms of preferring one version rather than the other, but I don't think we need to get into that this afternoon. All right, 227, offences to be TIC'd or taken into consideration. I'm sure you're all familiar with this as a concept. Defendant is pleading guilty to the offence or offences with which they are charged and asks for other offences with which they have not been charged to be, quotes, taken into consideration by the court. Prosecutors in courts like that. Defence advocates tend to like it as well, so everybody's happy with that. So it's generally a good thing. As it says, it clears up unsolved crimes. The court likes it because it means that if the defendant is running an argument, or their advocate is running an argument, that they regret their past conduct, they wish to turn over a new leaf, make a fresh start, etc., then the kind of voluntary disclosure of greater offending than the authorities have the wherewithal to charge you with does tend to give greater credence to that type of argument. So that's why courts are quite happy for defendants to offer TICs. On the other hand, as it says there, care must be taken not to abuse that process. Now, I'm not sure how far one goes with not abusing that process. If you look at some of the examples that you've got there, so Garnham, which we've now got on the screen here, although it's reported from a kind of disparity, so from a sentencing point of view, disparity, so an appeal against sentence, alleging an inappropriate disparity between co-defendants. What we've got there is the appellant being sentenced in the Royal Court to 36 months youth detention for 6 burglaries, 2 cases of taking driving away, not a partridge in a pear tree, 2 motoring offences, and 38 TICs, of which 31 more were burglaries. So that's a total of 37. 6 he's been charged with, and 31 others that he said, that was me as well. I'd done them. Yeah. So as you can see, skipping over the kind of disparity argument there, the last highlighted passage, his criminal record was such that this was a perfectly proper sentence. His 36 months youth detention was a perfectly proper sentence, which would have been a lenient one had it not been the court taking into consideration the guilty plea and the admissions relating to other offences. So the TICs, fairly self-evidently here, in the case of Garnham, were seen essentially as a mitigating factor. Yeah. Again, if you compare that with the situation in England and Wales, the Sentencing Council in England and Wales takes a slightly more ambivalent position as far as TICs are concerned, and wants to kind of make the point a lot clearer that if you ask for, in this case, 38 other offences to be taken into consideration, then surely that means that there's a greater level of criminality involved here, and that ought to kind of, it should be an aggravating factor. So, all right, yeah, you get some credits and kudos for voluntarily implicating yourself, but at the same time, the level of criminality has gone up. Now, frankly, I think where that leaves us is back where we started. In this case, probably it's just been entirely beneficial to Mr. Garnham rather than back where we started. And generally speaking, that's why defendants sometimes do it because they genuinely want to make a fresh start. They are genuinely repentant of their past conduct. Frankly, most of the time they do it because they think it serves their interests. They're going to get a lighter sentence by acknowledging this. And obviously, there is the remote possibility that at some point in the future, the police may decide to investigate these other 38 crimes and come up with some admissible evidence that suggests it was Mr. Garnham who was behind them, and prosecute him, and then he'd be sentenced. So he's kind of taking himself out of harm's way by having the TIC, because he's not going to be looking at a separate sentence for 38 other crimes. And yet they're basically off the books, not just as far as the authorities are concerned, but as far as Mr. Garnham is concerned as well. So TICs, generally speaking, he loves them. Yeah. As I say, procedure mustn't be abused. I'm not quite sure how far you have to go in order for it to be an abuse. 38 crimes there. For me, that's teetering on the brink of abuse, if not smashing right through the fence of abuse. And a similar example with the case of White in T29. Pleads guilty to 1 offence of burglary and has another 26 taken into consideration. Hey, it's just taking the mickey, isn't it, really? Anyway, there we are. So yeah, where do we switch from candour and remorse into abuse? I don't know. But these must be on the edge, I would have thought, if there is an edge. You can't stop it. I mean, obviously, if you start offering to TIC crimes that there's no evidence of crime ever having happened, then why would you? But no, I think that's right. If you've got someone that's already going down for something which they're obviously bound to rights on, and you can throw in a few more of these, and it works for you. Never mind the 20,000. It works for you because you're going to get a lighter sentence. Why wouldn't you just, all right, Jim, I'll take the fall for you. That's fine. Have this one on me. Yeah, I'll sure you do the same for me. Really? I mean, you can't. There's no way, and that's just just life, isn't it? I mean, you're kind of coming back to a fundamental point, which is an ethical point, really. Is it for us to kind of probe and interrogate? So when Mr. Garland comes along and says, there's another 38, I'd like to have TIC, then we're going to sit down and go, well, are you sure that's you? Are you sure not doing your favour for Big Ron? Yeah, are these all attributable to you? You're not going to do that. You're not going to sit there and go, yeah, is that really you? Did you really do that one? I don't think people do that. I don't think anybody. I think everybody's so happy that the defendant is being candid about their conduct that nobody's. It serves nobody's interests to poke and prod too much on that one. We're all too busy clapping and going, well done. You've seen the error of your ways, and possibly several other people's ways as well.
Can I say
I don't withdraw on a point if it's so rare, but so it does effectively close off future prosecution of any of those other things.
Well,
Someone else wants to play next?
Yeah.
But I just said the reason to start investigating, we must let this.
Yes.
No, it's dead in the water. Yeah.
But it is actually quite rare.
Yeah, but then in practice, maybe we don't reclaim it, but this seems a bit extraordinary.
Mm.
Then in practice, if you find the property in someone else's, who then admits to it, and they have evidence that it was actually that person. And the other 24 other burglaries were actually also used.
Well, then you'll
Then
you
you then get dragged for
Arguably, I mean, the reality is, of course, that with all of these TICs, Garner, let's stick with Garner because he's on the display there, but he's never been charged. At no stage has he been formally charged with those 38 other offences. Yeah? Typically, the way it works is that the defence, or maybe the defendant in person, depending on their relationship with the local law enforcement, but typically the defence lawyer is instructed to then approach the prosecution, the police, and say, look, we're minded to offer some TICs. Are you okay with that? And they say, if they go, oh yeah, all right, well, let's see what you've got then. The onus is on the defendant to come up with some details, because obviously the theory is that the police either don't have enough evidence to show who committed the offence. They might not even have any evidence there was an offence committed in some instances. So the onus is on the defendant to actually provide some detail. Typically what would then happen would be, this is probably a 2-page job, the prosecution would then draw up a schedule of the different offences with as much factual detail as they feel is necessary to give a kind of flavour of what's gone on. And then they will prepare that. They'll hand it over to the defence lawyer, who will then show it to their client and, right, run through each of these, just have a look at them. Are you happy to acknowledge that they are all down to you, which gets us back to the kind of doing a favour for Jimmy type of thing. Really. That's as close as we're going to get to that. Are you happy, in other words, that you're not TICing something, you're not going to sign off on something that you don't want to be TIC'd? So you're happy that we're going to TIC all of these, and even at that stage, the defendant might turn around and go, oh, actually no, that one's not mine. I don't know where it came from, because the only information has come from the defendant. So I suppose it's possible the police might try and slip in another couple that have been on their to-do list for a long time. I don't know, but yeah. So I've no defenders sit there and go, oh yeah, that's not me. Cross that one out. And you just cross it out. The prosecution is generally quite happy with that. And at the end of it, there'll be a little kind of declaration saying, I ask the court to take all of the above matters into account when determining my sentence. Signed, Mr. Defendant, love and kisses. The end. and then that just gets handed in to the court when basically either when they're going through the antecedent history or when the defence is making its plea in litigation. And that's as formal as it ever gets. So, perverting the course of justice, I can see it's tempting, but I think it's legally, I think it might be a big step to take.
I suppose given out credit for it.
Yeah,
It might be.
yeah. I mean, if the prosecutors really felt that they'd been made mugs of,
Yeah.
then they might be incentivized to take retribution or seek it anyway. Yes. Okay. All right. Diverting children. I'm not sure that there's a lot in this section that we didn't already think about, and that we're not going to come back and think about a little bit more when we think about juveniles in chapter 6, if memory serves me correctly. So I think we might just pass over that for the time being. First appearance at 2:35. Yes, everything starts in the magistrate's court. There is, I believe, no way for, let's say, HM Procurator to instigate proceedings directly into the Royal Court,
No.
which certainly is the case in Jersey in certain circumstances. They can just be indicted straight away without ever having gone through the magistrate's court, but that's not the process here. So everything starts off at those first instance tribunals, the magistrate's court, Court of Alderney, or the Court of the Seneschal. So it says 236 for less serious matters. I'm tempted to say trivial, but less serious criminal matters. The prosecution will normally be proceeding by way of a summons. So that will hopefully come through the post, I expect. So, be served in person.
Delivered by the police officer.
Is it? Okay. All right. Yeah. But obviously, with a summons, the system is trusting the recipient of the summons to turn up at the appointed time and place. It's like receiving a party invitation. Yeah.
It's not through the sergeant, I think it's done through the police.
But if it work, it'll never be the post because service is always biased to the sergeant.
Well, I'm not sure, and I'll find that and we'll clarify, because I'm not sure that the traffic summonses don't appear to come through the post.
And certainly England and Wales, summonses are always going to come through the post.
I'll find that.
Yeah.
Because we don't get involved in those things, so I'm not sure that. Family member appeared before the magistrate's court proceeding the other day.
Have a word.
How do you get your summons?
Yes. Yeah, all right. So as it says there, at 237, in a more serious matter where perhaps there's a little bit more at stake, the defendant perhaps has a greater motivation not to simply rock up in response to the invitation. So as it says, most criminal defendants on a serious matter will be charged and then either put on police bail to attend or perhaps even kept in custody and produced in the magistrate's court. As it says, police can impose various conditions of bail after charge. Okay, we're beginning to shade into bail, which we'll look at in chapter 3 in a few minutes' time. But pre-charge, as it says, the only condition that they can impose is requiring re-attendance. So they will bail you with a condition you come back to the police station, usually on a specified date, by which time they will either have determined they have enough evidence and you'll be charged, or they still don't have enough evidence, or they're never going to get enough evidence. So they might just release you, terminate the bail, you just released, or they may, again, bail you to come back on another date. Yeah. Are you saying there's a forward?
Sort of protocol, which I'm not totally familiar, but they are not bailing anybody for longer than 28 days. We ought to get the details of that for you. It's causing some problems because very often if 28 days they haven't achieved anything, so then what they do is to release people without charging them, the rest of them get a later. That's not very helpful. But it's supposed to be, it's part of this, which is also not in the guide because it will know that there's now a case management protocol also need to introduce these guides so that you're aware that it's part of that seeming like the meeting in press. There's been a bit of chat about who's legislating, who's supposed to.
Yeah, I was saying it's I think symptomatic of almost the kind of backlash against the kind of Paul Gambaccini situation where people are not charged and they're on police bail for maybe months, a year, just kind of dangling. Right, okay. So 238 then, once there's actually been a decision to charge, then the custody officer will need to make a bail decision. The officer in charge of the case will prepare a remand application if they're going to ask for bail to be withheld and the defendant to be remanded in custody. If indeed bail is refused, then he will be kept in custody to appear before the next sitting of the Magistrates' Court. 239 I think we've already dealt with, so we don't need to do that again. 240, mode of trial, I think we dealt with that this morning as well. 242, I think we've pretty much covered that this morning. Yeah, all right, 243, prosecution will make representations to the judge about appropriate mode of trial. That's going to be in a situation where presumably HM Procurator does not want to insist on having trial in the Royal Court, but wishes to assist the magistrate in making a decision about whether they have adequate sentencing powers, or for some other reason the matter is not appropriately dealt with at the Magistrates' Court's level. As you can see, I think it's again something that Mark touched on yesterday. Drink driving offences would normally be picked up fairly obviously by the Magistrates' Court, but the third or subsequent such offence may well mean that the matter is committed to the Royal Court for trial, partly probably because of the likely sentence that's going to come for the defendant if convicted of that matter, probably being outside of the magistrate's jurisdiction to impose. Okay, what else do we need? Procedure on sentencing, 244. Prosecutor will read a summary of the facts to the judge, because obviously if there's been if there's a guilty plea, the court will not necessarily have all the facts before it. Certainly if it's first appearance, prosecution won't have produced statements or anything like that for the court, so they'll have to give a factual summary orally to the court. Defence presents a plea mitigation, and if we don't have to adjourn to get a social inquiry report or a psychiatric report or a medical report or anything like that, sentence could be passed immediately, which comes back to Catherine's point from this morning about making sure that your client, if you're thinking a fine is the likely punishment, that they turn up with some money.
I think that that's all accurate what you said, but in practice it happens slightly differently.
Mm.
So you're going to enter a guilty plea, something very straightforward. The person has no previous convictions, the disposal is going to be a fine or not a custody charge. That's exactly how it happens. And the facts are there to do it in litigation. The fine is imposed and everybody goes well. If, however, it's a matter where there's going to be a possibility of a custodial sentence, so previous convictions, serious offence,
Not in here, no. Mark did mention them.
That's to do with drink driving and commuting 3 times a week. But anyway, more than 3 times a week, it's a custodial sentence. So if it's on those situations, the judge might not be ready to go to the judge might say, I get to go to or something. And I say, yes, sir, I will stop there. You might do the facts or anything. If it's more marginal, and so it depends on the facts, prosecution will then read the facts, and then there'll be a discussion about whether there's a report needed. Usually, because of the mitigation or some of the mitigation, But I would say that if we're heading down the Court Road, we're normally going down there long before the defence advocate is using that. Because it's usually obvious, because of the nature of the offence. I don't know if that's a slightly different practice.
No, I don't think so. That makes perfect sense to me.
And so that's really duty of care as well, isn't it?
Yes. Yes.
And it's sort of getting people to understand that the sentencing process has the lower end disposal of the probation, look at all of those in sentencing, and then you get to the custody threshold. And then if it crosses the custody threshold, it's only then that the court can consider commuting that custodial sentence into a suspended sentence or a community service order. Many people will always assume that the sentencing hierarchy is fine, suspended sentence, community sentence, and custody, if that's not the legal framework, it has to cross the custody threshold, and that's community service or suspended sentence. Even though suspended sentence isn't a proper penalty.
That's getting off, isn't it?
Yes, well, because if you're never going to,
Yeah.
you're never going to suspended sentence,
Or be prosecuted for committing an
well,
offence.
it's subtle, but
They'll never catch me.
yeah.
That's okay.
So the suspended sentence is still showing your record.
It's a
Yeah,
conviction
yeah.
of custodial sentence. So it's a serious conviction. It's just that it doesn't look like a serious penalty. Why it completely fell out of fashion when the community service provisions came in. Everybody forgot about suspended sentences. I'm a great fan of the suspended sentence. When I rock up on my periodic appearances, I'm always talking about it.
Yeah, it's a strange beast, the suspended sentence, because I mean certainly the position has changed relatively recently. I say in the last 18 months, but in Jersey for many years they were very kind of anti-suspending sentences. If, you know, the philosophy there was if a custodial sentence is appropriate here, then that's what you should have, a custodial sentence, the end. Yeah? And they would only suspend if there were exceptional circumstances. So that's one moving in one extreme. Moving to the other extreme, in England and Wales, the position for quite some time now has been, as a part of the sentencing process, when you get to a point where you have concluded that the offence is so serious that it crosses the custody threshold and only a custodial sentence will do the job here. Yeah? The next question you're going to ask yourself is, can I suspend it? That is the next question. Not like, are there exceptional circumstances? It's the logical, natural, common next question. Yeah. Does it have to be immediate, or can I suspend it? And if I can suspend it, that's what I should do.
And that's sort of what the government's I went along and started talking about exceptional circumstances, and the magistrate said, yes, but I think in England the learning has moved and I don't have to have it. And I said, great, thanks.
Yes.
So, you know,
Yes.
no
All
doubt.
right. Just a quick point, because again, I think we'll come back to this in our next meeting. But 244 also makes the point that entering a guilty plea is a powerful mitigating factor. Usual to recognise that with a reduced sentence. We will come back to that, but you can see one example is Ryder from 2009, and that's what you can see on the screen here. Credit for guilty plea, paragraph 29 onwards in the judgment. Submitted by Advocate Green, who's representing the defendant. Advocate was entitled to the usual 1/3 reduction, having entered his plea of guilty at the earliest opportunity, accepted that there was authority in the Pareto case that there may be exceptions to the rule that pleading guilty normally leads to reduction in sentence. For example, when an accused was caught red-handed or had no real alternative but to plead guilty. Now, that situation used to prevail in England and Wales. It doesn't anymore. Okay, within the last, I think, 12 months, the Sentencing Council there have issued revised guidance about reduction in sentence for guilty plea, and they no longer effectively penalise you for being caught red-handed. Yeah.
Interesting, because we're going the other way here.
Yeah.
We're typically seeing in the Royal Court a quarter, a discount of a quarter.
Well, if we read on with this guide, then you can see in our judgment, the applicant had no real alternative but to plead guilty. Paragraph 31, the reduction in sentence of 1/4 to take account of the applicant's guilty plea appears to us to be merciful, balanced, and fully justified. Observed in Perito, the authority that was being referred to, the court upheld a sentence that made no allowance for the guilty plea. Yeah. Right, okay. Jogging on to summary trial, I think at 2:47. How do we do the time? So, summary trial. So in terms of starting, the charge gets read out and the defendant is asked to plead. That may be the first time they've pleaded. They may simply be either confirming or revising the plea that they previously entered. Note that the plea can be entered either personally or through the advocate. That again, I think is a subtle difference with England and Wales, where it has to come from the accused in person. It will be set aside, or could be set aside later on if it's the advocate that enters.
It's usually the defendant.
Yeah, well,
It's usually the defendant.
as you can see, then if the defendant pleads not guilty, prosecutor introduces their case, calls their evidence, with the emphasis being typically on live oral evidence given at court, usually with the witness being physically present in the courtroom, with chief cross-examination on behalf of the accused and then re-examination if thought to be necessary. The judge in the magistrate's court may also ask questions. Yes, John.
So, Miss McMillan is very much a judge's question person, and ever since she came here, we've all been arguing with her about it, because my view is that if the judge asks questions and asks something which raises a matter of interest, I should be allowed to go back and ask further questions. Yeah. And sometimes she allows it, sometimes she doesn't.
Okay, well, that's interesting. I mean, certainly in my experience, any time, maybe not so much with lay magistrates, but that's not what we're talking about, certainly with the judge in the Crown Court, if at any point they asked a witness some questions, they would then, maybe as a matter of courtesy, but they would then always say, anything arising, counsel? Yeah, and is there anything that you want to? And generally speaking, you're already in tears at that point because they just demolished your brilliantly constructed case with 2 or 3 pertinent questions. So there's nothing you can do now to shore it back up again. So you might as well just throw the towel in and possibly ask for the charge to be put again and we can plead guilty. Try and claw back some.
It's a hazard.
Yeah. But no, I agree. I think certainly my experience is if they do step in and start asking questions, then whether it's a matter of courtesy or not, my expectation is that they would always say, anything arising. Do you want to ask any questions on the basis of what I just persuaded the witness to talk about? Yeah. And it's often quite depressing because I say you may have been carefully tiptoeing around a particular event or some particular aspect of the case very carefully in your cross, and then the judge kind of crashes in with their size 12s and undoes all your good work, and you're sitting there going, well, why did I bother then? Yeah, okay, fine. Let's just plead, get it over with. Okay, so this isn't new to you guys, is it? Prosecutor, when they finish their evidence, closes its case, defence can make a submission of no case, prosecution can react to that. If the submission is successful, that's the end, the defendant is discharged. If it's unsuccessful or it's not made, the trial carries on, removed from the defence case. It says evidence can be called for the defence, no surprises there. If the defendant is going to testify, then they would normally be called as the first witness. That's exactly the same in England and Wales. Section 79, PACE 1984, obviously different provision here. Section 75 of PACE 2003 for Guernsey. Obviously, the reason for that is to avoid the defendant kind of tailoring their evidence to fit in with other defence witnesses, if there are going to be other defence witnesses, because the defendant will be physically sitting in court hearing that. And I'm assuming that the same provision applies here as it does in England and Wales, that in a criminal case, generally speaking, the witnesses other than the accused are kept out of court until it's their time. Yeah. Okay. As it says at the end of the defence closes its case, the prosecutor may be allowed to make a closing submission if the defence made an opening statement. As it says, that's not usual, but in any event, the defence always gets the last word. So it's kind of converse of what's civil, where the plaintiff will always get the last word. Okay?
There's this bit about the prosecutor not having a closing speech is quite contentious and going to. It happened in an arson case that I was doing where it came out for the first time, and I made a case of I made a submission of no case to answer, and the prosecutor, and it wasn't successful. And then we didn't call any evidence, and we didn't say anything further, because I didn't actually close the case. I just sat down and said, right, that's fine, that's done. And the prosecutor wanted to come back and say something, and it wasn't allowed. And we'd not called any evidence.
Yeah.
And he was found not guilty.
Yeah, but no, absolutely, because you can use it
very,
tactically.
very contentious. Very, very contentious.
Well, I can understand the prosecutor being upset, but that's
Yes.
too bad, isn't it? Yeah, no, well done. Yeah. So tactical decisions. Yeah. All right. Variation between charge and evidence. 249. Generally speaking, as it says there, no objection may be made to any defect in a charge or summons, whether of substance or of form. Similarly, no objection to any variance between the allegations and the evidence that's actually produced, unless the variance is such the court feels the defendant has been misled. In other words, it's not going to happen that often, but where there is some kind of slip, like maybe, I don't know, the victim's name has been wrongly entered in the charge, something like that, not going to be a problem there. So it says if there is a risk of the defendant's being misled, then the cure almost certainly is going to be adjourn and allow the defence to get its ducks lined up appropriately, and then resume from that point onwards. 250, law officers against Bullock was an example of where there was a very late amendment of the charge against Mr. Bullock. It's not a particularly legally significant case. As it says there, what the Lieutenant Bailiff said was it might have been more satisfactory if the charge had been amended at an earlier stage. I don't consider the late amendment has occasioned any injustice or prejudice. The appellant satisfied he is properly and rightly convicted. I don't know whether you're familiar with this case, but Mr. Bullock is a prize idiot. He was driving out. There were two police officers, yes, it says with a roadside speed gun, and he was driving some flashy vehicle up and down the road. He went past them about 3 times and then parked in a house across the road. Then came out with a friend of his with a camera, started taking photographs of the police officers with their radar gun, and then went over and, as one of the PCs said, basically invaded her personal space, asking what they thought they were doing there, and making some point about a local group of, I'm going to say boy racers. Kevs, yes, exactly what it says in the judgment. Kevs, yeah. But yeah, so they arrested. In the end, they arrested him for obstructing an officer in the execution of her duty. I mean, seriously, what an idiot! You couldn't make it up. But, anyway, yeah, all right. So yeah, so basically, what happened was he was charged with obstructing 2 officers in the execution of their duty. The evidence came out at trial that really, at the appropriate moment, one of them had gone back to the patrol car to answer her mobile phone. So maybe she wasn't executing her duty and he wasn't obstructing her. So they just struck out one officer's name, and that was the amendment. So you can see how there's no injustice there at all, but a very late amendment. Okay, financial allowances for witnesses. As you can see, under the magistrates' court's fees rules, a witness can, on the court's say so, receive an allowance for up to £104 for each half day when they are required to attend at court. And if they're necessarily absent, I can't imagine why that might happen. I suppose maybe someone that's resident outside of the jurisdiction can be paid a night allowance to cover costs actually and reasonably incurred for your board and lodging. Okay, witness summons. Obviously,
Just
yeah,
need to make you aware that we as advocates have the ability to generate our own witness summons.
Oh, okay.
If I generate a witness summons and the person doesn't appear, there's no penalty.
Mhm.
So if I wanted to issue a witness summons for someone to go to criminal trial, I would be more likely to ask the court to do it.
Yeah.
But we do have our own power of advocates to do it.
Okay. Would you need to accompany that with an offer to pay their, or a declaration to pay their expenses?
No.
No.
You just say so.
But it doesn't have any teeth.
Sorry?
But what you just said, it doesn't then have any teeth.
It doesn't have any teeth, but
So it looks nice and-
you might do it in circumstances where a person says, "Oh, I need a summons for it because otherwise I won't be able to get out of work," or whatever. If the person's going to come, but there needs to be a formality about it. It's not often used. But we have one or two perks.
Yes, reasoned decisions. I think we've already spoken about that today, and we spoke about it yesterday. You can see magistrates ought to give reasoned decisions, matter of human rights, and the case of Alan there, having heard the evidence, if the magistrate said, having heard the evidence, I found the version given by the prosecution is essentially correct, I was sentenced on that basis, yeah, court would be happy with that. So it's not like you have to give war and peace to justify your decision. Okay, also 254 the graph. Adequacy depends on the nature of the case. So decision to prefer one medical expert to another would require some detail, some explanation. Decision to convict for speeding would not usually require much. So there we are. Now, my heading of recusal, Catherine would like me to say what? Recusation. Yeah.
I think correctly in Guernsey it's called recusation, but increasingly in the modern, even the judges are talking about recusal.
Barbarians.
Yes.
So, 255 then. As you can see, yes, it's a small jurisdiction, small population, and you get what? Yeah, frequent flyers turning up again and again. So yeah, the court may well become familiar with, oh, it's Mr. Smith again, or Mr. Snooks, and they'll be very familiar with what? Mr. Smith's criminal history, because they've played a major part in formulating it themselves. So obviously Mr. Smith might become a little bit aggrieved by that, and generally speaking, it's just going to be tough, realistically speaking. But having said that, as you can see at 256, Deputy Bailiff has said that there may be occasions when a judge ought to recuse themselves. Special connection with the defendant or special knowledge of the defendant's propensity to commit a particular crime. But simply knowing that the defendant has pleaded guilty to some charges and not guilty to others, and you're sitting now adjudicating on a trial of those other ones that they pleaded not guilty to, in the knowledge that they pleaded guilty to some of the other ones. So it says it's unlikely to cause the judge to be prejudiced against the defendant. Yes, judge knowing witnesses. That's what's dealt with in 257. So you can see there, a nice example. Burton, in 2006, Burton appeared in the Magistrates' Court charged with sending menacing phone messages to the Deputy Sheriff, who therefore was obviously going to be a witness or potentially a witness in the proceedings. Before the hearing started, the judge of the Magistrates' Court stated that she knew the Deputy Sheriff in a working capacity. Well, Kelsa Freeze. Okay. So Burton was convicted and appealed against that conviction, alleging apparent bias and claiming that there should have been a recusation. Royal Court looked at claims of apparent bias and came out with exactly the same test that would apply in England and Wales. So would a fair-minded and reasonable observer conclude there's a real possibility or a real danger of bias? Court was sure, taking into account judges' professional training and their judicial oath, they would be able to act impartially, even when hearing evidence given by a person who they knew in a professional capacity and observed on a small island. It was inevitable that court officers will know each other on a professional basis. So,
and I think that's to do with proportionality. I think that if somebody was accused of seriously harming the Deputy Sheriff, or it was a matter which was likely to carry a long custodial sentence, then they might at that point start thinking about doing something from Jersey. it's a hazard of working in a small place.
Yes, okay. So slip rule, I think we've already looked at slip rule this morning, so we don't need to go through that again. Likewise, committal for trial, we've already had some time thinking about committals for trial. You can see at 2.60, there's some material there as far as the old style is concerned. Given what we've already said this morning, I think I'll leave you guys to have a look at that. We need perhaps to focus on the new style of 262. I would just say there's a small typo at the end of 261. Penultimate line, it should say a shortened procedure, not a shorted procedure. It should sound like some electric shock. But that's not correct. What else do we need to think about? Yes, all right. I think we can probably skip down to 264. Yeah, go on.
And it came up recently. If you do a new style committal and you effectively let it go through, you don't make any submissions, you don't call any witnesses, you don't make any comment, your client doesn't make any comment, are you still able to make submissions in the Royal Court that there is no case to answer? And it was just a prosecutor who was trying to make the point actually in the de Kock case, but because in the de Kock case, and I wasn't instructed at that point, he accepted in a very positive way at committal that there was a case to answer, so that when I then came to make an application in the Royal Court, so that there was no case to answer, we were in some way hamstrung. And I think it may be to do with questions being slightly different. That's different points in England. But the view that's taken generally, and there was a discussion between myself and the magistrate recently, the view that's taken generally is that that can't be right, because you're not asked to accept that there's a case to answer. The court has to decide whether it considers that there's a case to answer at committal. All that you're doing is saying something or nothing, not positively. So I think it's just it may be, if you're sure that you're going to want to make a submission of no case to answer in the Royal Court, then it may be as well to be absolutely clear that you don't accept that there's a case to answer by going through the new style committal.
I think that's very, very important, actually. Yes. Okay. 264, as it says, the previous couple of paragraphs are looking at the committal proceedings written statements rules of 1983, but I think we can probably kick in with 264 because it says that really the evidence requirements have been replaced by the Administration of Justice law of 1991. And as you can see under section 1 of that law, a written statement by any person shall, if certain conditions are met, be admissible evidence just as if that person had given oral evidence to the same effect. And those provisions apply to committal proceedings. And you can see the 4 requirements that there are as far as the 1991 law is concerned. Just to be crystal clear, 265 talks about the same 3 additional formalities still applying here, and that's a cross-reference back to 263 and those 3 bullet points that you've got there. The difference being, as it says, under the 1983 rules, it had to state the age of the witness if they were under 21, whereas for the 1991 law, as it says, age has to be stated if under 18. So there's a slight difference there. And you can see that there are penal sanctions for willfully making false statements. Yes, it's 267, extremely rare that live evidence is now called, rare that a submission is made, also rare that if it is made, it's made successfully. Yeah, 268, kind of housekeeping really, where a defendant is committed to the Royal Court for trial, the judge in the Magistrates' Court will ask the defence to indicate what the likely plea will be at the plea directions hearing. The defence have a complete choice as to whether to go along with that or not. But of course, if they do indicate a guilty plea, then that's all grist to their mill in terms of mitigating factor when it comes to sentence further down the line. Likewise, the judge can ask which prosecution witness statements like to be agreed so that we don't need those people to be warned to attend at the trial. And as it says, these indications are not binding, but can assist with case management, which is, as Catherine's already indicated, a growing sort of looking for a pattern as far as criminal proceedings are concerned. So the judge makes any bail decision that is necessary, and then formally commits the defence to stand trial, and will give a date for plea and directions hearing. I'm hoping, well, actually, if it's all right with you guys, finish off this chapter, then we'll have another break. Yeah. So, advance notice of expert evidence. If we look at it now, it will save us perhaps some time in the chapter on evidence a bit later on. So, as you can see, expert report is admissible in evidence in criminal proceedings, whether or not its maker is called to give evidence. Although if its maker is not being called to give evidence, you're going to have to ask for leave to rely on the report. And as you can see, there are some rules, criminal procedure advance notice of expert evidence rules 2003 made. Those rules don't apply when expert evidence is being tendered at a sentencing hearing. So something maybe like a psychiatric assessment, that sort of thing. You don't need to go through the advance notice requirements under the rules. But if you are proposing to call expert evidence, then you have to, in other circumstances, you have to supply your opponent or opponents with a written statement that sets out the fact or opinion from your expert. And the other party says can then make a written request to be given the records of any observation testimony, in other words, the raw data on which the expert's opinion is based. That request has to be complied with unless it seems to be more practicable to simply allow the other parties a reasonable opportunity to examine the record for itself. And advance notice may be waived by opponents. Non-compliance with the advance notice requirement, well, as it says, that may be a legitimate response, okay, if the party considers that if they did comply, that could result in an attempt or actual intimidation of the expert, or otherwise lead to interference with the course of justice. So if you are going to knock back the advance notice obligations and handing over the data, that type of thing, then, as it says, you have to give notice to that effect in writing and the reason for doing so, and then presumably the party that was seeking the disclosure can then take that before the court and seek an order compelling you to make the disclosure. So it says 272, if a party doesn't comply with Rule 1 for any reason, they have to get the court's leave to reduce the expert evidence, and that's Rule 3 of the advance notice rules. So, having got to the Royal Court, the next thing that's going to happen is a plea and directions hearing. There is a practice direction on that, practice direction 2 of 2003, and you can see that, in theory at least, there should be a PDH held in the Royal Court within 4 weeks of committing the trial, whether the defendants have been remanded in custody or committed in custody, or 6 weeks when they are on bail. Parties should have at least 14 days notice of the PDH, not least because they will need to get the paperwork in order before that hearing. As it says, notice requirement is sometimes waived, and maybe you may have a PDH very rapidly indeed. It's a housekeeping hearing, so as it says, 275, purpose is to make sure all the necessary steps have been taken to prepare for trial. The expectation is the trial advocates will attend the PDH wherever practicable to do so, because what nobody wants is you have some kind of discussion or decisions being made about, for example, the admissibility or inadmissibility of a particular piece of evidence, and then we rock up to the trial. There's two new faces standing there in place of the people that turned up to the PDH, and they, or one of them, has a different view, a different take on whether something was admissible or inadmissible, and we end up, everything starts to unravel again, and the PDH turns out to have been a bit of a waste of time. So nobody wants that. So it should be the same advocates turning up to the PDH as it's expected will be conducting the trial. Anything else that we want to think about? Just to make sure that things move efficiently, as 277 says, if the defence lawyers receive confirmation instructions from their client, basically he's going to plead guilty to everything before the date of the PDH, then they should immediately notify the court of the prosecution, because then everybody understands what's going to happen at that hearing. Yeah? So defence will typically request the court to order a social inquiry report, so there'll need to be an adjournment for that. And as it says, the court will usually need to adjourn anyway, because on a PDH, it's just a judge sitting alone. Because it's decisions of law effectively being made, you won't get the jurats there. So if you have to proceed to sentence, if that's the logical next thing to be done, then you need jurats, they're not there, so we'll have to adjourn to actually get the jurats to come in. 278, if your instructions conversely are that it's still going to be a not guilty plea, so there will have to be a trial, then it says have to give the prosecution a full list of those witnesses whose attendance is required. Because it may well be that you're quite happy for certain witnesses' statements to be read out and not contested. And then you can save them the aggravation and the inconvenience. So 279, as it says, clearly important that defence lawyers can obtain instructions from their client, and according to practice direction 2 of 2003, if they're unable to obtain instructions, they should apply to the court for the case to be listed for mention. And as it says, typically that has undesirable consequences. You know, your client is not going to love you if you have it listed for mention. All sorts of consequences may follow, including, for example, if they don't turn up, a warrant being issued for their arrest. Yeah, it doesn't look good. So I would suggest, although it says they shall apply to the court for the case to be listed for mention, you might want to think seriously before taking that step. It could lead to should we say, a worsening of the relationship, possibly a terminal worsening of the relationship. Yes, all right, case summary. Prosecution should prepare a case summary for the judge's use of the PDH. That's what it's basically meant to do. The hearing itself will usually be an open court. Defendants should attend, and therefore, unless they're given permission not to attend, they'll be in breach of their bail if they don't rock up.
What's your view about prosecutors saying that they will release the case summary or opening until they read it out of the trial?
What, release to the defence? Well, my view on that would be that's strictly following the terms, isn't it? Because it's, I mean, it does say should prepare a case summary for the judge's use of the PDH, but then I think strictly that I would say that's probably compliant. But then from a practical point of view, as defence advocate, you're really you're participating in a discussion with one arm tied behind your back, aren't you? Because you don't know what their take is.
And what happens occasionally is that they don't do it at all. They don't prepare it for the judge, but they don't give it to the defence either. So you don't get it until the case opens.
Well,
would that not be usual in England?
No, I mean, I think the absolute expectation is the prosecution will provide a case summary, and there's no. I can't think of a situation where the content of a case summary should not be disclosed or disclosable to the defence. As I say, from a defence advocate's point of view, you're participating, going to be participating in a three-way discussion in which the other people usually have access to information and under an understanding of what the case is about that you're not privy to. So
it's not that happens. I think it's just that, like many of these things, in accordance with the direction, but there have been occasions when the opening has not been given out to other places.
Yeah.
Which then prompted an application to adjourn to consider the opening.
Well, I think that's perfectly legitimate. Yeah.
You've got to know what the case is about, really, and I think you've got to press for sufficient information, whether it's in the form of a letter or anything, particularly if it's complicated.
Well, I mean, if we've got the form, and if you think about some of those questions, how long is the trial likely to take? Prosecution witnesses to be called to be read. you know, I'm not sure that you can intelligently answer those questions if you don't know what the prosecution's case is. Okay, all right, trying to speed things up a bit. I think 282 is pretty self-explanatory. The form, I think, is informative in terms of the work that the court's going to be doing or expecting the advocates to do on the PDH. So, for example, at point 9, we can see there if there are any kind of special measures that are being sought, those should have been thought about, and any kind of argument to justify. You should come along with the PDH with those arguments all prepared and ready to put before the judge. All right, trial in the Royal Court then at 283 and the indictment. If anybody isn't qualified in England and Wales, this may be shockingly new to you, but assuming that we all are, I think it's pretty much as you'd absolutely expect it to be. So 2 component parts, statement of the offence, the particulars of the offence. There's nothing novel or unusual, I think, to talk about there. 284, if you were confused when you read that because it refers to the example count given above, above should be replaced with below, because that's where it is in that grey text box. And you can see that you can have an indictment charging multiple offences together in the same indictment as long as they meet the rules on joinder. Okay. And again, that is now a different position to England and Wales. The rules on joinder have basically been done away with as far as putting counts onto an indictment concerned. So you could have all sorts of counts with completely unrelated offences on a single indictment. And so the joinder kind of test, which you've got in 285 about fathoming the same facts or forming a series of offences of the same or similar character, a test known and beloved to bar students down the decades, is no longer a test as far as joinder is concerned. In England and Wales now, under the criminal procedure rules, it is a test in terms of whether the judge might exercise a discretion to order separate trials of these different provisions. But there's nothing that says that they cannot appear on the same indictment. So theoretically, you could have an indictment with either murdering, a count for murdering somebody, and count 2, I think, setting fire to a house 2 years earlier. Yeah, absolutely nothing, no legal nexus, no factual nexus at all. They can now appear quite legitimately on the same indictment. Yeah, it is very weird. Anyway, so the rule on joinder, as you can see in 285, is the long established one, found in the same facts or a series of offences of the same or similar character. You've got an example in the case of Hastie at 286. I'm not going to put that up here, but obviously one of the considerations that the court might have there would be cross-admissibility, and you've got that reference there to similar fact evidence. That's not a necessary requirement for them to appear on the same indictment, but it's certainly a strong argument for having them on the same indictment, having a single trial of those various matters if there's going to be cross-admissibility. Because, of course, the typical direction is to look at the evidence on count 1 for only count 1, look at the evidence for count 2 only on count 2. If they're cross-admissible, then that's a powerful argument for keeping them together and having a single trial. Yeah. Separate trials, again, a very standard provision there. If the court thinks the defendant may be prejudiced or embarrassed because he's facing a single trial on multiple offences, then they can order a separate trial, but frankly, they very seldom actually do, in my experience, order separate trials. Judges can normally find very compelling reasons for keeping everything together. Don't worry, I can give perfectly adequate directions. Fact finders are not morons. They can understand my directions and treat all of the evidence on each count separately, if indeed that's what has to be done. They won't be prejudiced at all. I can run with school.
You should have the jurat then, because of course they're a higher
form,
so
yes.
they can be directed.
Yes. All right. It is indeed. It's certainly if you're defending. Yes. As you can see in 288, again, thinking about tactically how these things run, you might run together an application from a defence point of view, an application to have separate trials with the different counts on the indictment, as it says there, in the alternative, a ruling that there's not been proper joinder, there's been misjoinder. So not found on the same facts or don't form a serious offences of the same or similar character. So an example, Dodd and Butler, again, it's a typo. D and B were charged with 2 separate acts of importing controlled drugs rather than importing controlled drugs. But that's quite an interesting little case to read. It's quite interesting. There's a lot of reference to smuggling drugs. I say smuggling I'm using very loosely here because the customs guys were just watching. They watched, I think it was Mr. Dodd, turn up on a jet ski. I mean, if you try to do things surreptitiously, I'd suggest coming in across the sea on a jet ski is not the best way to not draw attention to yourself. But anyway, here we are. So jet ski in a rib craft. I don't know how else you could do it, but anyway. So as you can see, the judge in the Royal Court referred to various similarities. And if you were defending, you might argue, well, what else is this? Is just what common law garden, what drug smugglers would do. They use a nautical craft. It has to make landfall. You're done. These are not striking similarities. It's just the stock in trade of what a drug smuggler that isn't using an airplane or a helicopter would do. Anyway, so the judge there found that this was a serious offence of the same or a similar character. And I've given you the arguments that the defence used. I mean, these are clearly 2 desperate men. So what was different? In count 1, a jet ski was used, whereas in count 2 was a rib craft. Massively different. 2 different landing areas. Yeah, the bags that held the drugs were different each time. Wow. I mean, talk about scraping the barrel. So, but it's an interesting case.
My colleagues
Well, I'm sure that was the best that was available. I'm not criticising, but in terms of quality, it's a desperate state of affairs, isn't it? Anyway, there we are. So as you can see, as it says at 290, severance, still sticking with Dodd and Butler, severance is a discretion for the trial judge to exercise. Court of Appeal, you seldom going to succeed in the Court of Appeal in complaining about the way discretion is being exercised. It's either going to be what? You've looked at irrelevant things, you've not looked at relevant things, or the decision that you've come to is manifestly unreasonable in other ways. All right, nothing else I think that I want to say about that. It's pretty self-explanatory. Amending 293, I think we've kind of looked at that already. Whittaker is a mildly interesting authority on that, where the original count had alleged larceny, contrary to the 1958 larceny law, and that had been replaced during 1983 by the theft law. And it turned out, as the evidence in the trial emerged, that the relevant date for the larceny/theft matter was slightly different to what had appeared during the course of the investigation. And that although what he'd basically done, the evidence was that what he'd basically done was committed theft, and he hadn't committed larceny. He was convicted. They substituted the count for theft, deleted the larceny. He was convicted of theft and an appeal against conviction. And the Court of Appeal said that essentially you couldn't criticise the defendant for misunderstanding the position. He hadn't deliberately misled anybody, and the elements of the offence of larceny were different, significantly different to the elements of the offence of theft, which is why the law got changed. And therefore the appeal was allowed, that they shouldn't have amended or been allowed to amend at a pretty late stage that indictment by switching out the larceny and subbing in the theft allegation. All right, bail, yeah, fine, nothing to add to that. Trial runs in the order that we would expect a trial to run. Jurats would be directed on the law in open court. It says there shouldn't be any less full than a summing up to a jury in England and Wales. Bailiff will also sum up on the evidence. In Jones in 2016, the court was asked basically to give its opinion on whether there should be a written route to verdict, which seems to be a real trend in England and Wales these days. So a series of questions to answer. If you answer this one, yes, move on. Do not pass go. Do not collect £200, etc., etc. And the court in Jones said no, that's not the case. Possibly because again, it's a different beast that you're dealing with. It's jurats rather than jurors. I don't know. That may be one explanation, but certainly they have not adopted that practice. And as the Court of Appeal observed, you can see at 297, if the defence thought that it was appropriate to have a written route, then they should have asked for one, and they didn't. Okay. Well, they'd heard of it by the time they appealed.
Yes, that's a different thing, isn't it? It's still not the case.
No.
It's still, I mean, they do some, they use one post, but I don't know what response you get if you ask for a written route. No.
Well, that was only back in 2016 when the Court of Appeal gave fairly short shrift to it. So you never know. 298, although the bailiff is summing up on the evidence, matters of weight, of course, are for the fact finders, the jurats, to determine. So as it says there at 298, the weight of evidence is a matter for the jurats, not something that they could or should be directed on by the judge. 299, majority, if need be, if it's not unanimous. We've already thought about that, I think, so I don't think that we need to go through the rest of that. We've thought about the casting vote in 2100, delivering the vote in open court, we've covered that. 2102, if we're moving on to sentencing, as we appear to be at that point, so the prosecution is not offering conclusions, which is a possibly unique feature of criminal procedure in Jersey. But having said that, as it says, the Crown still has a duty to assist the jurats when asked to on issues of sentence, and clearly owes a duty to the court to make sure that the sentence is a legally valid sentence. So if it looks like the jurats and the judge are kind of going completely off the reservation in terms of the sentence that is being imposed, then the prosecution should be standing up and saying something about that. All right, Burton, I think we've already looked at today. There is a typo there, so it's at the top of page 55. It's not 2016, it's 2012. It's quite an interesting little case, but I'm not going to say any more about that. Basis of plea document in 2103, we've already thought about that, and Newton hearings, so I don't think we need to cover that anymore. Lodging of papers, it's basically housekeeping. I think you've got everything that you need to know about in there. And appeals, 2107, we've already basically covered how the legal aid would extend to advice on appeal, any ground for appeal against conviction or sentence. Yeah. Oh, is it? Okay.
So you're saying that they were actually, so the one from earlier today is the reference of 2005, 6, and then 31, this one is 12.
Okay.
So are they related though?
No, I don't think so. Yeah, sorry, yes. So there's one, this one, 2005-6, which is all to do with recusation, as we can see in the heading there. Yeah, so that's that one. That was the one with the threats against the deputy sheriff, and the other one, which I think is this one that we're interested in. Is it? Let's have a look. Scroll down here. Felipe Nelson Burton. Yes. Oh yeah. Sentencing process. Yes. Yeah. I mean, it's quite an interesting case. The Court of Appeal observed for the first time in the court's history, composition has included two members with extensive experience of sitting as judges in the Royal Court. In those circumstances, an opportunity has been provided to describe the constitution and composition of the Royal Court when sitting to try cases committed to on indictment, blah, blah, blah. Sorry, with all due respect. Paragraph 30, once they've delivered their verdict, their roles change dramatically. It's just a nice little exposition of process. basically by people who know what they're talking about, rather than people who've been parachuted in from some other jurisdiction. Yeah. So yeah, sorry. So they're not in any shape or form related. Right. 10 minutes. 5 minutes. When you're all back, we'll start. I'll leave it to you guys. Oh dear, oh dear. I've definitely written too much on evidence.
I quite enjoyed the refreshment.
Yeah, I'm just not convinced we're going to get through it in under an hour and a half.
So, yeah.
I suppose I could just do chapter 4 and leave chapter 3 on bail to the next weekend.
I was just having a look. I have to say. Yeah. I mean, the evidence sections. I mean, bail is important. Evidence isn't important, but bail is bail, really.
Yeah.
People just need to understand how it works. There's one thing, it talks about surety, but it doesn't talk about security. Does it?
Yeah, it's pause.
Yeah.
Do you want this door left open? It's very warm. Is it? I'm nervous of expressing an opinion about that.
Not controversial.
Yeah. Yes, almost as controversial as the whole tea coffee thing. Right, okay, so we are now recording again. I was just having a quick chat with Catherine about tactically how to manage the rest of our time this afternoon. And I think what I'm inclined to do is to defer chapter 3 for the time being on bail and just focus our attention on chapter 4 on evidence, because otherwise we'll do chapter 3 and a bit of chapter 4, and I don't think that's going to be very satisfactory. So we'll skip chapter 3 for the time being and just focus on evidence. Okay, so, and it may be we can short circuit some of this, but so page 72 is where we kick off, and as you can see, 4.1, typically we're looking at live oral testimony from a witness who's physically present in the courtroom, but increasingly these days we're also looking at statements made by the witness prior to their use in court, and that could be in the form of something that's agreed by the parties, should be adduced in that form, and no one's really kind of interested in challenging the content of that statement. Or of course it could be that it's a highly contentious statement, but it's still being offered as on a hearsay basis in lieu of the witness. You could have that. You could have the use of pre-recorded video interviews being offered in evidence. You could have witnesses testifying live in the sense that they are in real time giving their evidence, but not physically present in the courtroom because they're on the end of a live link camera somewhere else, possibly somewhere else in the same building, or just literally somewhere else. So lots of different variations there, but I think it's right to say that nevertheless, still the main preference of the system is for a witness physically present in the courtroom giving live evidence. Yeah. Probably the single most important enactment here is the one identified at the end of 4.1, Police Powers and Criminal Evidence, Lady Wicked Guernsey Law 2003. And when in doubt, refer to that, I think would be my key advice there. Moving on to possibly the section that caused the adjuncts that reviewed this chapter to say that I was babying you too much. There is material on relevance, admissibility and weight, and I'm quite happy to skip over that if you feel that you are fully up to speed on all of those key concepts. If you did want to have a look at something, the Anthony John Jones case at the end of 4.4 on page 73 is quite a nice little example of the court thinking about what does it mean to talk about the relevance of evidence. So if you've ever felt concerned about that, it's an interesting little case. I think it's also an example of one that Mark and I had a brief discussion about yesterday when we were talking about illegally, when we talked about the Warren case as well, illegally obtained evidence and the admissibility of that. So yeah, the Anthony John Jones case is quite a nice one to have a read through. But really kind of getting stuck into to burden and standard of proof then at 4.9. I haven't really found much kind of discussion or judicial consideration or agonising over what we understand to be either the burden or the standard of proof. Yeah, in Reynolds from 2003, there was a passing reference, a very passing reference to it. Generally, it just seems that everybody assumes, without really discussing it explicitly, that the prosecution bears the legal burden of proof unless there's some specific basis for it to be placed on the accused. Okay, and there may be situations of that happening. As and when it does, no doubt, defence advocates will pray and aid the human rights law and say that this is entirely contrary to Article 6 of the ECHR and yeah, should not be allowed for. We can also see in 4.11, as well as the kind of explicit reverse burdens, where an enactment uses a phrase like the proof where offshore rests on him, i.e. with reference to the accused, I mean, that's an explicit reverse burden. There may be, as it says in 4.11, implied statutory exceptions, where it's only the courts that are able to intuit that there's a legal burden of proof being placed on the accused. Section 3 of the Administration of Justice law from 1991 that's referenced in 4.11 is fairly standard one, as it says in 4.12. It's pretty much identical to Section 101 of the Magistrates Courts Act 1980, which if you did your bar or solicitor's course in England or Wales, you will have encountered. Basically saying that if you're relying on an exemption, excuse, a qualification, a proviso, a license, permission, etc., then the legal burden of proving that you have that is on you. It's not for the prosecution to prove that you didn't have the permission or the license. Yeah? So to take an obvious example, having a full driving license, so you didn't need to have somebody supervising you in the passenger seat of the vehicle when you were stopped driving it by the police. The onus is on you to provide your driving license, not on the prosecution to contact whoever they are these days, DVLC or DVLA in Swansea, and show that you don't have a license. Okay? And that's for a number of reasons, not the least of which is ease of proof. Yeah, you're the one that's saying you've got the license, you've got the permission. If you had it, you'd have a firearm certificate, for example. Yeah, you're found in possession of a gun. You say that you're entitled to have the gun because you've got a firearm certificate. Just produce the certificate, show us a bit of paper, and we'll all go away happy and get on with our lives. Okay? So, as it says in 4.12, any implied statutory exception must now be open to challenge on the basis of incompatibility. Article 6. This is a little passage taken from Blackstone's Criminal Practice 2019, and given that it's talking about Article 6, you can see Article 6.2 states everyone charged with a criminal offence shall be presumed innocent until proved guilty according to law. So it's pretty obvious there that the legal onus of proving something should be on the prosecution to prove guilt rather than the defendant to prove their innocence. 4.13, an example of a situation where this court, the Royal Court, implied a legal burden of proof in a situation where, on the same wording, the identical provision, English courts have not gone that far and said that there's anybody who bears a burden of proof. And this was to do with excluding what I've abbreviated to being unfair evidence. So evidence, the admission of which would have such an adverse effect on the fairness of the proceedings that it would not to be admitted into evidence. So that's section 78 of PPACE, which is the identical twin of section 78 of PACE 1984 in England and Wales. You've got this case of Rose. I'm going to call it Rose, might be pronounced differently. If I think it's Miss Rose were here, but as you can see, court there observed that in considering the evidence, the burden of proof was placed on the Crown, the prosecution, to the criminal standard. Not clear from English cases where the burden lies, because English cases have veered away from ever talking about the burden in this context. Okay, so this course was deemed safest. Fair enough. Just a couple of points while I'm looking at my notes. I didn't put in a full reference, I apologise for that, for the Rose case. It's an unreported case. It's case 60 of 2017, and it's a first instance case. Well, it's a Royal Court case. So 60 of 2017, and the passage that you've got there comes from paragraph 3 of that judgment. So it's possible that there'll be a reverse burden of proof placed on the defendant explicitly by statute. It's possible, and section 3 of the 1991 law is an example, where there may be implied statutory exceptions. Also, insanity. Insanity is the third of the situations where typically one has a burden of proof, legal burden of proof on the accused. And that's applying the Norton rules. You can see there is a particular example of a case in Guernsey, the Harvey case at 4.14. Bailiff held that the defence of insanity was available to the accused when charged with murder. So that's the only offence really that's going to play a part. Similarly, the jurats could find the accused not guilty of murder, bless you, but guilty of manslaughter by reason of diminished responsibility. So Harvey's an interesting case. I think that's the first time that the Guernsey court actually acknowledged and allowed a defence of diminished responsibility. There's nothing in any enactment that provides for that. So there is in English law, I think it's section 2 of the Homicide Act, 1957. But there's nothing to that effect actually in any Guernsey enactment. Okay, so the bailiff basically read that in and said that was a legitimate alternative verdict, not guilty by reason of diminished responsibility, but guilty of manslaughter. So as it says in both instances, the bailiff said the legal burden of proof would rest on the defence to be met on a balance of probabilities, which is of course the typical standard that would apply where the defence bears a legal burden. There's a little bit more chat in 415 about standard of proof. Nothing, I think, of any controversy in there whatsoever. Just again, I've got a little quote from Miller against the Ministry of Pensions. It's a very old case, but I've referenced Blackstone's Criminal Practice 2019, and just to follow that to the end of the trail of breadcrumbs. That's at section F at 3.53. Should anybody be infused enough to actually look it up, F 3.53. Right, witnesses. Can't live with them, can't live without them, as they say. So 4.17, basic rule, mustn't impeach the credit of your own witness. I mean, query, why would you want to do that? Generally speaking, of course, that's the last thing that you want to do is impeach your own witness's credit. So you can't ask questions or reduce evidence that show their bad character or their criminal convictions or their bias, one way or the other, or refer to any previous inconsistent statements they have made. That is, of course, entirely the job of your opponent to be doing in cross-examination. Yeah? However, leading questions, as it says, may be used by an advocate during chief where a topic isn't disputed because that saves time, or to elicit a denial. Yeah. Did you hit him over the head with a big stick? No, I didn't. Okay. As it says, otherwise it's technically difficult to draw out the testimony. Okay. So generally speaking, where it's a contested matter, however, leading questions should only be used in cross. Okay. So you can't cross-examine your own witness unless they are declared by the judge to be hostile. I've got too many that's at the end of that line. This means only one that. He is not desirous of telling the truth to the court, the instance of the party calling him. That's what being hostile means. As to be distinguished from simply not coming up to proof that they're pretty crappy at being a witness, or they've got a really bad memory. That's just being unfavourable, and you wish that you were doing something else today. Hostile means that we're all pretty clear that they could be giving version A, but they're actually giving version B. Yeah. Probably because they've already given version A in a statement weeks or months earlier, but they're now giving version B. And version B probably is actually very supportive of the other side. Yeah, so they've really kind of like jumped over the fence and become a kind of a mole for the opponent. That's what's really meant by hostile witness. So apply to the judge. If the judge agrees that they're hostile, then you can use leading questions and indeed put their previous inconsistent statement to them. Here, I think the hearsay rules are such that putting their previous inconsistent statement to them is still only used to show their inconsistency, and therefore you're undermining their credibility. Whereas again in England and Wales, these days, since the 2003 Criminal Justice Act, if you cross-examined your own witness as a hostile witness on their previous inconsistent statement, under the provisions in the Criminal Justice Act 2003, that previous inconsistent statement itself becomes evidence of the truth of what it says. So it's kind of like the witnesses arguing against themselves, effectively. But it kind of, the idea in England and Wales was to get away from that kind of mind scramble that jurors are asked to engage in, and I guess jurors still have to engage in, although they're better equipped to do it, obviously, when they hear about the terms of a previous inconsistent statement, and then the judge says to them, that's only evidence of this witness's inconsistency. Yeah, don't really pay any attention to what they said in their previous statement. It's just to show that they've been inconsistent, which reflects on their credibility or your assessment of their credibility. And, you know, so the fact finders are warned off of relying on the content of that earlier statement for the truth of what was said in it. In England and Wales now, they can actually look at it for the truth of what was said. Yeah, and it's said that that's both sensible and avoids any kind of brain melt on the part of the fact finders. I haven't found anything that has a similar consequence as far as Guernsey is concerned. So if you are going to be introducing previous inconsistent statement, it's only going to be useful to show simply the fact of inconsistency. Yeah. So unless if it's your witness, I mean, obviously you, as a cross-examiner, you'd be making as much use as you could of previous inconsistent statements. But yeah, if it's your witness, they're hostile and you're still examining them in chief, technically speaking. The only point, realistically, of trying to shred their credibility through introducing a previous inconsistent statement is if they have given what you consider to be evidence that damages your case. Because you're trying to basically, if it was a game of chess, you'd be trying to sweep them from the board, basically just take them out of the game completely. Because this is not about rehabilitation, it's about destruction. All right, okay. 418, collateral facts. So as it says, those that aren't connected directly to a fact and issue, there is a rule of finality. We're all okay with that? We understand the rule of finality? No? No. All right. So collateral facts like credibility. So for example, you couldn't see clearly what was going on because your eyesight's very bad, isn't it? Yeah. Or you couldn't understand the conversation the two men were having because they were speaking in a language that you don't speak. That's right, isn't it? Yeah. So things like that basically would go towards the credibility of the witness. So you couldn't understand it, you couldn't see it, those types of things. Or you'd previously had a massive argument with Mr. Defendant, hadn't you? Yeah. So you weren't very well disposed towards him. About that, and you're not well disposed towards him now. In fact, you're biased against him, and that's why you've come to court to tell lies. Isn't it? No, I'm not telling lies, etc. So, collateral facts would tend to be ones that in a broad sense, attack a witness's credibility. And the rule of finality is because they're collateral, because they're not the facts in issue that the court has to grapple with and try and resolve, the court doesn't want to spend too much time worrying about it. So there's a rule of finality that says you can put your point. This is about cross-examination. You can put your point to the opposing witness. Once they've answered that point, move on. Okay, don't spend 5 minutes, 10 minutes, half an hour just hammering away on that topic. You've asked your question, they give you an answer, move on. It doesn't mean that you have to accept the answer, but you asked it, you got the answer, let's do something else now. Competence and compellability. I don't think there really is much in terms of competence, really. You can see at 419, as it says, that should be your first question. Is this witness a competent one? And only if the answer to that is yes, do you go on to think about are they compellable or not. The Loi Relative au Preuve of 1865, I can't remember what that is in French off the top of my head, but anyway, it's quite a long time ago. Witnesses are deemed to be competent unless proper reason is shown to the contrary. So in other words, we'll assume that your witness is competent unless the other side managed to persuade the judge that they're not competent. Okay. The Loi Relative au Preuve, I'll see if I can track it down. I haven't found it on the Guernsey Law website, and I did do another search for it last night. I still can't find it. Yeah, thank you. Yeah, that would be helpful. But I, at some point in time, I've had it because I know I've read through the different articles, which is why you've got some specific references to articles that relate to it. But anyway, key point: witnesses deemed to be competent unless an opposing party manages to persuade the judge that they're not. If they are competent, they'll be competent either for the prosecution or the defence, unless they happen to be either the accused or married to the accused, and indeed still married to the accused. If the marriage has come to an end, then they can quite happily be competent for the prosecution. Minors are competent to give evidence as long as the court satisfied they have the necessary knowledge and understanding. So Article 3. And if, as it says, if an objection is to be made to a witness giving their evidence, you need to do that before they've taken the oath and started. Compellability, nothing really to say there. If they're competent, they'll also be compellable, generally speaking. That's quite a general principle there. There are exceptions, of course. The accused is not compellable to testify, certainly not at the behest of the prosecution, because that would infringe the privilege against self-incrimination, as well as probably some other fundamental human rights that I can't think of at the moment. The spouse of an accused, that's picked up in 421. And as you can see there, at 422, PACE, where are we? Yeah, section 82, provides for the spouse of an accused to be compellable as a witness. So she's compellable for her or his spouse, the defendant, yeah, but compellable as a witness for either a co-defendant or for the prosecution if there is a specified offence involved. Okay, obviously not compellable if they're also accused in the proceedings. So if you had a kind of a, I don't know, Fred and Rosemary West situation where Fred hadn't actually killed himself, and they were both standing in the dock awaiting trial, then Rosemary West wouldn't be compellable to testify with the prosecution against Fred, or vice versa. You know? Specified offence defined in 4.23. This is really just working through the same provisions that you've got in section 80 of PACE in England and Wales. So again, if you are familiar with that, this is identical to that situation. The basic point being, just very quickly, there's a public interest in not forcing, which is what compellability is about, not forcing one spouse to testify against the interests of their fellow spouse. It doesn't do a lot for marital harmony. Yeah? People can have a row about it and fall out. So public interest is in kind of preserving marital harmony. There's also kind of, I don't know, semi kind of religious overtones or undertones about husband and wife being one entity. Yeah, so if you forced a spouse to testify against a spouse or defendant, that would be like breaking the privilege against self-incrimination. I mean, I know it's not, but That's an argument. So there are public interest arguments in saying that the spouse cannot be compelled to testify essentially against the spouse, defendant, yeah, either for a co-accused or for the prosecution. But against that, there may be other competing public interests that say, well, actually, we want people that commit certain offences, certain bad offences, to be taken down. We want them to be convicted, and we should do everything to ensure that they can be convicted. And one of the ways to ensure they can be convicted is by maximising or optimising the evidence against them. Yeah? And that's why you've got 4.23 in that list of specified offences, because Parliament, or the states in the case of Guernsey, has decided that those specified offences, the public interest in enabling a conviction to occur outweighs the public interest in preserving marital harmony, yeah, and recognising the unity of husband and wife. So it's really a battle of public interest. Yeah, before we leave this place, just so that my conscience is slightly clearer, footnote 326 on page 76. There's a reference there to Stephen's Digest of the Law of Evidence, always a great read if you've got time on your hands, but quoted in Blackstone's and then I was forced to look this up because I didn't understand why I put a slash instead of a stop in there. And the good news is that it turned out to be the wrong reference anyway, so it should say F6.46. I mean, I said this is the teacher in me coming out. The hope that you will go away and ever look at Blackstone's Criminal Practice 2019 and turn to F646. Yeah. See, it says that there. Good, well done everybody. Yeah. But anyway, let's see. Cracking on. What else do you need to think about? Yeah, all right. I think that's probably enough. You can read the rest of the stuff on spouses. There's nothing particularly problematic there. Except let me see, 4.26. Yes, as I said, this is almost a word for word replication of section 80 of PACE 1984 from England and Wales, this provision about spousal compellability, except section 80 of PACE has been updated so that it doesn't only apply where you are husband and wife, but it also includes civil partners. Okay, the provision in PPACE, if I can call it that, from Guernsey, has not been amended. So it remains an interesting question. Possibly isn't a question. Perhaps the answer is obvious. But
has it been amended for the same-sex marriage?
In England and Wales, I don't think. No, pretty sure it hasn't. So anyway, the last time I looked, it still refers to spouse in the sense of husband and wife, but maybe it's implicit. I don't know. But there's an interesting point to be taken there. Right. So accused and co-accused, as it says at 427, then it's entirely up to the defendant, the individual defendant, to decide whether or not they wish to testify. It's something we talked about earlier. That's the sort of discussion that you will have, your client will expect to have and get your opinion about, but ultimately it's for them to decide. And I would say if you have any kind of sense of doubt about this at all, it's always a good idea to have a little attendance note and just get, say, for the client to sign off on. Yeah. Having been advised by my advocate, I've made a decision myself on my own free will that I will / will not testify in my defence. Yeah, delete which is not applicable, and they get to sign it with data, so that when they appeal against their conviction in a few months' time, and one of their grounds of appeal is that they desperately wanted to testify in their defence, and the big bad advocate that was representing them at their trial, actually refused to call them to testify, even though they were desperate to do that. You've got some kind of insurance policy to say, well, look, we discussed it. I asked him to sign off. It was his decision. There's his signature. Thank you very much. I'm covered. Yeah. So I would say that's the sort of conversation you need to have. You need to get something in writing from the client. I think if you've got any doubt about their kind of bona fides at all,
Or even if you don't.
yeah, but you know,
Because
it's self-preservation.
Even the nicest people, if it goes the wrong way, will-
Yeah, they'll look for reasons.
It's probably the single most important, apart from the truth, that's got to be taken to whether or not the person gives evidence. I mean, sometimes there's no choice, but where there's a choice, it can be really finely balanced. Because you can have a very good case that's completely ruined in a few minutes of them opening their mouth.
Yes. Right. Okay. Okay. Other things for us to think about, though. Yes. If a defendant ceases to be an accused, which they could do, for example, by pleading guilty, which would mean, of course, they're no longer accused of something, they've acknowledged it, or the prosecution dropped the charge and offer no evidence against them, then they would be competent and compellable to testify against their former co-defendants. Okay. Fairly sensible. Let me see. Didn't want to go through 428. All right. Yes. Okay. Question of timing. This testifying against your former colleagues in crime, your former associates in crime, obviously can be a good thing. And I think again, this is a point that was picked up by Mark yesterday afternoon about the mitigation that can accrue to you. And you can see a reference halfway through 4.28 to typically a sentencing discount of between 1/2 to 2/3. And that is a great result for someone who's looking at, frankly, almost any sentence, really. 1/2 to 2/3 off. And you imagine if this was a sale, you were walking past a shop and they had this big poster with it that said, 50 to 66% off. Yeah, you'd think carefully about whether you wanted to go in there or not, even if you didn't think they sold anything that was of interest. 50 to 66% off. I'm going to go and have a look around. Yeah, you never know what's available in there. So that is a big incentive, a big inducement. It's also, of course, a big fat incentive to tell lies about people. Yeah, so there is a problem there. It's kind of I don't know. It's a bit of a bargain with the devil, isn't it? Really. And there is an issue about when our former co-defendant, our person that's turned, I guess, state's evidence. Is it state's evidence here?
Yeah,
Queen's evidence. Okay. Whether there's some kind of unholy alliance between them and the prosecution and the judge to stitch up this poor innocent remaining defendant, in order to get this 1/2 to 2/3 reduction in their sentence. You'd say anything against my client, wouldn't you, to get your 2/3 reduction? No, I'm telling the truth, nothing but the truth. Yeah. Okay. So that's the big question. When are they going to be sentenced? That's part of the deal. Yeah. You're just doing your damnedest to take my client down with you in the hope of getting a big fat reduction in your sentence. Yeah. So in order to avoid that kind of fairly standard defence argument, cross-examination, there might be a temptation on the part of the judge to sentence the former co-accused, the guy that's now turned Queen's evidence, pleaded guilty, said I'm going to testify for the prosecution against D2, to sentence D1 before they give their evidence. Yeah. Except, do you really want to do that? Because you're going to sentence them on the basis of this huge mitigation that they've now got. They've agreed to testify against the co-accused. You sentence them on the basis that that's what they're going to do, and then it all goes to pot when they step into the witness box, or indeed even refuse to step into the witness box. Because what are you going to do? You sentence me now. Yeah. So it's a kind of horns of a dilemma situation for the court. Sentence now and preempt that defence argument. Yeah, you're just trash talking my client in the hope of getting a lighter sentence, or leave the sentencing to the end. It's problematic. Anyway, I think that's probably more than I've spent more time talking about it than there is words in 4.28. So we will move on. 429, we've already talked about calling the defendant first if he's going to be testifying and he's one of a number of defence witnesses. Sworn and unsworn evidence, 4.30. The expectation is that witnesses will give sworn evidence. That could be through a religious type oath, or it could be through an affirmation, a secular affirmation. either of those is acceptable in this jurisdiction. As you can see, if a child of tender years, and that's not defined anywhere that I've found, but a child of tender years, it's a very well established, a very old expression that's used in the law of evidence. But a child of tender years doesn't understand the nature of an oath, in other words, their obligation to tell the truth. Yeah, it says the child may give unsworn evidence so long as, in the opinion of the court, the child has sufficient intelligence to justify receiving their evidence and they understand the duty to tell the truth. Right now, that is a very old test that basically doesn't apply in England and Wales anymore. As you can see in footnote 337, these days, if you have a child aged under 14, that might be understood to be a child of tender years, if one was going to try and define that expression. They have to give unsworn evidence. So the court doesn't have to even bother about any consideration of their intelligence. Do they understand the duty to tell the truth? It's just, if you're under 14, you're giving unsworn evidence, end of story. Yeah? And there's no differentiation in the weight to be attached to that evidence. Yeah? I mean, the reality, frankly, is it's of no practical differentiation. I mean, I don't think most people these days, if they take an oath, I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and the truth. I don't think they're expecting that they will face eternal damnation. Yeah, somebody dressed in red with a couple of horns prodding a trident in their backside for eternity. If they should happen to tell lies whilst they're in the witness box, I don't think anybody really thinks like that. So the reality is, this is just what, as a long stop, if you want to prosecute them for perjury a bit further down the line, that's what it's really there for. Otherwise, well, I'm getting philosophical now. Yeah, all right. We'll move on. Corroboration. I don't think that corroboration is still really a very live requirement as far as Guernsey law is concerned. Certainly, if we look at 4.34, you can see there, any rule requiring a child's evidence to be corroborated was abrogated, abrogated in 1991. And furthermore, the requirement for a warning, a corroboration warning, to be given to jurats about convicting an accused on uncorroborated evidence of either an accomplice, so we're back to telling whose evidence again there, or the complainant in a sexual offence trial. That requirement for a warning has also been removed as from 2002. And in my note says that's section 14, for those of you that are particularly enthusiastic about following these things up. As 4.35 says, you can still find reference to corroboration in contemporary law reports in this jurisdiction. And a fairly recent example is the XY case in footnote 342 from 2016. But I do have to be fair to the court there and say, to be fair to them, that was in the context of a reference to an English case dating from 1993. And in 1993, English law still had some rules around corroboration. So it was relevant in 1993, and the court here was talking about the case in 1993. So I think it's just really a historical accident that they found themselves referring to corroboration there. Right, how are we doing? 20 odd pages to go. We can do this. Talk less, cover more. That should be my motto. Hearsay. Yeah, okay. Assuming that we all understand what hearsay is, if you learnt about hearsay in the last 10 or so years in England and Wales, you need to kind of rethink it. If you learned about it before then, you're good to go. The law on hearsay in Guernsey is that a hearsay statement is one given other than in evidence in the current proceedings, which is offered as evidence of the truth of the things that it says. Yeah. We'll have a look at an example in a minute, but that's basically it. So simply, it's an out-of-court statement that is being offered as the truth of the things that it contains. Right? And that's it. If you're offering out-of-court statements for any other reason, say for example to show that Fred was capable of speech, at that time. And I know he was capable of speech because he said, yeah, 2 bananas for £1. Yeah, okay, all right. No one really cares whether it's true that you could get 2 bananas for £1 when Fred said those words. It's just whatever he said showed that he could talk at that time. Yeah, fine. So you're not relying on it for the truth of what was said. If, on the other hand, you are relying on it for the truth of what's being said, then it's going to be hearsay. Right? And you're going to find some basis for then making it admissible. So you can see, for example, in 439, this case of Albert Le Prévost. So again, quite an interesting little bit of social history from 1980. A guest house, somebody that was working as kind of a kitchen hand on a fairly casual basis, was found on the floor of the guest house kitchen whilst the guests were, I think, actually being served with their breakfast in the dining room. Defence case was there'd been no altercation or struggle in the kitchen, where both the victim and the defendant had been before the victim was discovered there. So 2 of the people that had been staying as guests at the guest house were called in trial to give evidence at breakfast. Mrs. Le Prévost appeared in the door of the dining room and said, "He's hit him, somebody help me, and will you help me?" First hitting the old man. Okay, and common ground between prosecution and defence, that was hearsay. Both of those statements were hearsay evidence because they were offered for the truth of what was being said. There had been an assault, and it was Burt that was responsible for it, the old man being the deceased. Okay? So those are fairly, I think, helpful examples of something that would constitute hearsay. It's an out-of-court statement because clearly she's not in court. She's standing in the door of the dining room at the guest house. And what she says there is offered for the truth. He's hit him. Burt's hitting the old man. So offered for the truth of what was said. Okay?
She's not a witness.
Because she's not compellable. Yeah. Yes, isn't marital harmony a wonderful thing? All right, so as we can see, that's the rule, but there are, and if it's hearsay, I should add, if it's hearsay, the general rule is it's not admissible. Okay, so once we've characterized it as hearsay, then we have to find a principle to make it admissible. Okay, so we can see, let me see. Yes, all right, so 4.42, first-hand hearsay evidence. Let's just run through some of these fairly rapidly. So a witness, as it says at 4.42, may be absent from trial or any other hearing for various reasons. But if they have made a statement in the document, then that statement, the documentary statement, is admissible as evidence in criminal proceedings, as evidence of any fact in which direct oral evidence fighting would be admissible. So coming back to Mrs. Le Prévost, had she decided, all right then, all right, I can't cope with it. Had she decided to testify for the prosecution, I presume she wouldn't have told us that she said those things. She could have just got into the witness box and said, I was in the kitchen, I saw Burt pick up a frying pan and smack the old man over the head with it. We wouldn't be particularly interested in what she rushed into the dining room to announce to the assembled residents there. But anyway, so question, could they have given direct oral evidence? If they were alive and available and willing to give evidence in court today, could they have said those things? Okay, that's the basic question there. And if they could have said those things, but they made the statement to that effect in a document, you can adduce the document and therefore the statements in it in one of those circumstances that we've got in 4.42. So again, not unusual. They're dead, not Mrs. Prévost, sorry. They're dead, unfit to attend as a witness because physical or mental reasons. They're outside of the jurisdiction. It's not really practical to get them to attend. All reasonable steps have been taken to find them. They cannot be traced. Or the statement was made to a police officer. The maker does not give evidence through fear or because he's been kept out of the way. And again, if you qualified in England and Wales since 2004, these will all be familiar to you as reasons within Section 116 of the Criminal Justice Act 2003 for introducing first-hand hearsay from what is generally described there as an unavailable witness, and that's what these are basically talking about. Obviously, our fearful witness is not physically unavailable, but you know they might be resistant to turning up. Yes, 443. If your first-hand hearsay is in a document that was prepared for the purpose of criminal investigation, then as you can see, you need to get leave of the court to give it in evidence. And it's an interest of justice test that the court is going to apply there. All right, I don't think there's much else that I need to say about that. I guess the point being that first-hand hearsay can arise in a number of ways. We tend to just kind of zone in and think about it as it's a statement, it's a witness statement made by an eyewitness to an offence to the police. Yeah, that's how this statement is coming to being. But it's a statement in a document. Yeah, what you're doing now, if you're making a note of something, yeah, unless you're writing, God, this bloke is an idiot, which is obviously not being offered as the evidence, the truth of what it says. But you know, you could be writing something in your diary, yeah, and if you're dead by the time the trial comes around, yeah, then what you've written in your diary could be offered in place of you. If you don't have you anymore, you've just got what you've written in your diary. It's still going to be first-hand hearsay, as long as it's recounting something you have directly and personally perceived. Obviously, if it says, "Yeah, Cindy told me that Dave was cheating on me," yeah, that's not going to be first-hand hearsay. Yeah. Yeah. Okay, there we are. So yeah, so if it's the deceased's diary, then you don't need to get leave of the court to reduce it as per 4.43. The point being that, in theory at least, when you made that statement in the document, you didn't realise that there was a criminal investigation / prosecution afoot. So maybe you didn't have the motive to make a false statement, to lay a false trail, if you like. But if you know that it's prepared for the purpose of criminal investigation, then you go, aha, this is my big chance to get Dave into trouble now, cheating on me all those times over the years. Yeah, and so that the danger of confabulations, or just lying basically, is heightened where you know the purpose is get the statement for a criminal investigation. So that's why you need to get the leave of the court, and that's why the court would apply an interest of justice test to make its decision about admissibility. The Royal Court has adopted, so this is quite important, I think, 444, Royal Court has adopted the English position on hearsay must not simply be nodded true. Right? It has to be thought about carefully. You can't go, whoopee, let's adduce some hearsay evidence. And you can see there the court stated, Royal Court stated, very helpful exposition of what should be involved, wholly consistent with the Guernsey statutes that were quoted earlier. And that's Z from 2016, so presumably a fairly contemporary decision. And if memory serves me correctly, one that crops up in a number of places in chapter 4, so probably quite a good one. If you're going to read one, quite a good one to have a read of. And having said that, I'm going to skip over it. 446. I think I was particularly asked by the adjuncts that reviewed this chapter to include a little bit about the chain of continuity. So yeah, for some reason the adjunct said, you don't need to worry about this sort of thing in England anymore, do you? I thought, well, nobody told me to need to worry about it. But chain of continuity over exhibits. So as it says there, if an item is found and is sent off to a laboratory for analysis, or if it's just found and kept by the police, you need to establish who had it, who passed it to who found it, what did they do with it, yeah? How did they do that thing with it, who did they give it to, how did that person deal with it, who did they pass it on to, how did it get to court today, who's had it, who's looked after it. Yeah. So yes, chain of contact. Well, I think that's it. So I was asked to include it. I've included it. I've told you about it. So we'll leave that there. Business documents, another big category of hearsay evidence. I'm not going as fast as I need to, am I really? All right, let's speed up a bit. Business documents. Again, you've got a definition of business documents there. Again, if you studied evidence in England or Wales, you'll be entirely familiar with this definition. Created or received by someone in the course of a trade, business or profession. The information was supplied by someone who may reasonably be supposed to have had personal knowledge of the matters it contains. So with a business document, you can have a creator, the creator of the document. You can have a supplier, the supplier of the information. They may be one and the same person. Yeah? If I write in a, I don't know, like an invoice, for example. That would be a business document. I write an invoice. I'm now billing the Guernsey, whatever they call themselves, Guernsey Bar or GLP, whatever it is, whatever entity is meant to be paying me for this. I'm invoicing you for X number of hours at blah, blah, blah. That's a statement that I have been here for X number of hours. It's just that, and I'm creating in the course with business, my business, and the information is supplied by someone, me, who may reasonably be supposed to have had personal knowledge of the matters that it contains. So for a business document, the creator of the document and the supplier of the information may be one and the same person. They may be two entirely different people. So for example, on a production line, you've got people that work in the production line. Every so often they pass information to a clerk in an office somewhere that says, I installed item 1234/5 on this piece of equipment, or for that client, and the clerk in the office makes a note of that fact and then invoices the relevant customer to pay for that thing, whatever it happens to be. So they can be two entirely different people. But as it says there, again, test shall be admissible as evidence of any fact of which direct oral evidence would be admissible. So in other words, if you called me to say how many hours did I spend this weekend, I could say that in court. If you called the supplier or the guy that worked on the production line to say which bit of kit did you call, in fact, they probably couldn't remember that, but theoretically, if they could remember it, they would be allowed to give that evidence. I fitted item 1234/5 to that piece of equipment. All right, okay. At the end of 447, you can see there that there may be other links in the chain. There may be intermediaries through whom the information passed from the original supplier, the person who had personal knowledge, through to the person that created the document. Okay, this will only in that situation continue to be a business document for these purposes if every person through whom that information passed handled it in the course of their employment or a trade or a business, etc., etc. Again, 448, one of the reasons why business documents are a big exception to inadmissibility as hearsay is because the court can rely on the fact that their sheer kind of mundaneness, their ubiquity, the fact that businesses create documents to help run the business. That's why they have them in the first place. They're not thinking, let's fit up Dave for a crime, and create this special document to do that. It's just, how many units did we fit today? Who was working on line 3? It's that sort of information the business needs for its own purposes, basically. So the risk of somebody malevolently putting in false information in there is close to zero, because you need to be a mind reader in order to do that most of the time. So that's the reliance, that's the guarantee that the court has for most business documents, because they're created in the course of business for the purpose of the business. Why would anybody be lying? Obviously, there's a possibility of error, mistake creeping in, but why would you lie, really? However, 448, if it's an ad hoc document, like, I don't know, the director of the Guernsey Law Bar, or whatever they are, is asked to write a letter to the court saying, yes, Mr. McPeak worked 15 hours over the weekend of the 5th and 6th of January 2019, because that's what they need as part of their fraud prosecution against me for submitting false expenses claims. Then when he makes that statement in a document, he knows that it's going to be used as part of the prosecution against me for fraud. So at that point, if he's still, he's been such a pain to work with over the years, he needs to go down for something. Let's send him down for this. Fraudulent statement, didn't work those hours at all. I've got the recordings to prove it, etc., etc. Right, okay, there we are, done, job done. So if it's an ad hoc statement, although he's only making it in his capacity as the director of the institute, or the director of GLB, whatever they are, so he's making it in the course of the business. Nevertheless, because he knows it has that ulterior non-business purpose, it's for criminal investigation or prosecution, that increases the risk of falsehood creeping into it. So as you can see there, it won't be admissible unless it satisfies one of those additional criteria that we looked at in 442, so unavailable or scared of me, that doesn't sound very credible, or can't reasonably be expected to recall the matters, taking into account circumstances, including lapse of time. And that's what's going to help your production line worker. How would he remember? Yeah, that it was item 1234/5 that he fitted on the 5th of October 2018. The poor son's doing it 8 hours a day, 5 days a week, 12 months of the year. He can't remember which particular thing he actually fitted there. All right, yeah, I've probably killed any enthusiasm that you had for either business documents or hearsay evidence generally, so we'll jog on from that. 449, you've got a reference to the Decode case. My note says for 449, have a look at paragraph 58 and its ensuing. I think it's 58 to 60, something like that. It might be 58 to 61. Exclusion of first-hand or business document. So having gone through blood, sweat and tears, thinking about, is it first-hand hearsay, is it a business document? 4.50, even if you can tick all those boxes, the court still has the power to direct that it's against the interest of justice to allow that evidence in, and therefore to be excluded. In an effort to finish in the next 30 minutes, that's all I'm going to say about that. Third exception situation, we thought about first-hand hearsay, we thought about business documents. Third exception, res gestae. Different people pronounce it differently, but I think even I pronounce it differently depending on the day of the week, but I'm calling it res gestae today. So common law exception, and as you can see there, Court of Appeal in the Le Prevost case said that the bailiff had been correct to admit the evidence of the two residents of the guest house on the basis of being res gestae. So they were hearsay because they were being offered, they were out of court statements. She's in the dining room of the guest house. They were being offered from the truth of what was being said in them. Bills hit the old man. So it's clearly hearsay, but admissible as an exception to the hearsay rule as res gestae. And you can see in the words of the Court of Appeal in Le Prevost there that the basic test as far as res gestae is concerned. So again, looking around for a guarantee of why this material should be seen as reliable and not dodgy. It's made in circumstance of spontaneity and involvement in the event. Thus, the possibility of concoction or fabrication could be disregarded. So it's sometimes referred to as like an overwhelming event has occurred. You are so in the moment, so shocked, it's so spontaneous that you just wouldn't have had the time or the inclination to have thought, right, this is now my chance, my great opportunity to get back at Dave for his continued infidelities to me over the years. You're so swept up in the moment that whatever you're saying, that's the guarantee of reliability, the spontaneity, the overwhelming nature of the events. How far that works with the Benford case that you've got in 452, I think is somewhat open to debate there. As you can see, very simple, two masked men, this is great, it's like the Lone Ranger and Tonto. Two masked men are committing a burglary. One man, known henceforth as Jay, caught by a police officer, shouted, "Run, Kerry, run." I mean, if you're going to commit an offence, pick someone with at least 2 brain cells to commit an offence with. Don't pick Jay because the bloke is an imbecile. Yeah, you might as well have said, "Run, Kerry, run," all the way back to where you live at 123 Acacia Avenue in Guernsey. Yeah, what a moron. Anyway, so the second person, who we'll henceforth know as Kerry, was seen by another officer to have a tattoo on his neck. And this led to Mr. Benford, whose name unfortunately was Kerry, being arrested and charged as the second burglar. So as you can see, Jay pleaded guilty and therefore, of course, instantly switched from being an accused and not compellable or indeed competent as a prosecution witness. As soon as he pleaded guilty, he became both competent and compellable to testify for the prosecution against his former alleged confederate, Mr. Kerry Benford. Yeah? So that's a nice illustration of, if you like, that particular example of becoming competent, compellable as a prosecution witness, having previously been an accused. Anyway, he became competent and compellable, but interestingly, he wasn't called as a witness. quite possibly because, as is often the case in this type of situation, the prosecutor took the view that he was too shaky as a witness to merit being called. Okay? In other words, he was probably going to turn hostile and say, when I said Kerry, I meant Jerry or possibly Terry. Definitely not Kerry anyway. So he wasn't called himself to give evidence, but the run Kerry run statement was given in evidence by the officer who claimed to have heard him say it. Okay? Benford was convicted and appealed against that. The Court of Appeal said the judge had correctly applied the test for res gestae, and you've got again a reference to that. Crown against Andrews in footnote 364 is the leading English case on res gestae. So yeah, that was basically that. Yes, interestingly, although the Court of Appeal said the trial judge had correctly applied the test and found it satisfied, he hadn't gone on to take a second step in the analysis. So actually, Benford is quite an interesting little judgment to have a look at. The point being that Jay wasn't an unavailable witness. He wasn't scared or dead or physically, well, he might have been mentally underweight, but he wasn't mentally ill at the time of the trial. So it would have been quite possible for the prosecution to have called him. They made a tactical decision not to call him. Okay. Now, what the Court of Appeal said was that this is where the judge had fallen down on the job. Yeah, had to consider whether it was right to allow the hearsay evidence to be given in the light of the availability of the maker of that statement. So he wasn't dead, he hadn't forgotten everything. He could have been called into the witness box and asked to repeat what he said, or even asked to identify who the person was. Yeah, do you see that person today in court? Oh yes, it's okay. Points over at the defendant. All right, that wasn't done, and as it says, that the simple fact that the person who made that statement has a criminal record or was a co-accused who has now pleaded guilty doesn't mean to say that that second step need not be taken. So that's really like an interest of justice point. Yeah, in other words, you can't, as a prosecutor, you can't go, oh, Mr. J looks a bit dodgy to me as a witness. I'm not sure he's going to come up to proof if we call him. I'm not sure he's going to say that it's Kerry Benford that was committing the burglary with him. Let's just sit tight with the police officer. I can rely on the police officer to say the words, I heard the words, run, Kerry, run. Yeah. And I've got another police officer say, I saw a tattoo on the other man's neck. I recognise that tattoo now on the neck of the accused. Okay, let's do that because that's making life a lot easier for them. And the Court of Appeal in Benford is saying, yeah, well, unfortunately, you're not going to have that easy ride. Yeah. You've got to be prepared to take the risk and call Jay, see what he says, how he says it. Dying declarations. Yeah, it seems that still exists over here. Yeah, let's save some time and skip over dying declarations. I don't think it can arise very often. Not too many people get murdered in Guernsey. No. And if they have been murdered, not too many of those manage to hang on until somebody turns up for them to make their dying declaration too. No. All right, good. So we'll leave that there. Exception 5, bankers' books. This is just a kind of like convenience point, really. Bankers are busy individuals. As you can see, there's a bankers' books evidence, Guernsey law of 1954. Basically, what this is, it's a specific example of the business documents exception. It's basically what it is. But bankers managed to get this in, because they are busy and influential people. So they got the bankers' books thing in ahead of general business documents that the rest of us have to deal with. So as you can see, the usual method of proof, where we have a banker's book, and you can see that defined in 454. Usual method of proof is for somebody that works for the bank to make an affidavit swearing that the relevant book is an ordinary book of the bank, and it's just a business document. The entry is made in the ordinary course of business. The book remains in the custody or control of the bank. So it's one that we can be reassured about. It hasn't left the bank's custody, so the information would seem to be reliable. It was made in the ordinary course of business, so nobody had any motive to put any fake news in there at all, and that's basically that. What else? No, let's before I turn over the page again, I'm very conscious of the fact I've given you the wrong or an incomplete reference, let me put it like that, at 363 Benford. Should I have whetted your appetite for actually reading the Benford judgment? It's Law Officers of Crown versus Benford, 1993, volume 15 of the Guernsey Law Journal. So it's volume 15 that you should be looking at there. And in particular, 82, so 16 is okay, but it's very much the edited highlights. 82 is a full kind of live action replay of the appeal hearing, and particularly, I think at page 59 of the GLJ volume, so page 59 at letter E.
Sorry, what was that last bit? Sorry, I said GLJ 15 and 16.
No, sorry, it's the 15 should come between 1993 and GLJ. So it's volume 15 of the Guernsey Law Journal, but at points 16 and 82, yeah. Sorry, that confused me yesterday when I was working through that, but it actually is at points 16 and 82. All right, okay. Exception 6, non-contentious witness statements. I'm going to skip over those because they're non-contentious. So where we all agree that something can come in, then it can. Hooray. Exception 7, confessions. So as it says, confession is a particular type of hearsay evidence, can be offered in evidence by the prosecution against the defendant where it's relevant to any matter in issue, unless it's excluded by the court, and that's provided for by section 76 of page 2003. Why might it be excluded? Number of rationales for that, but it might be excluded because, 467 I think is where I pick up, and I'll come back to that. Eighth exception, pre-recorded evidence in chief. Again, we'll come back to that a bit later on, but this is intended to assist vulnerable witnesses. So if you have a vulnerable witness, which might be the victim of a sexual offence, it might be a child witness, it might be an elderly witness, maybe someone that's beginning to see the signs of dementia, perhaps. So there may be all sorts of reasons why someone is vulnerable, but special measures can be offered, and that would include perhaps pre-recording their evidence in chief. Okay, so that can be adduced in place of them. You've got the example of Z, and I think we have looked at that one before, and I did say it's an important one to have a look at. It's a very sad case. The complainant was terminally ill with brain cancer, and they'd intended to pre-record her evidence in chief, and unfortunately she died even before that could be done. She'd previously given a recorded Achieving Best Evidence interview, and the prosecution applied for permission to adduce those as, as I say, pre-recorded evidence in chief. And you can see also at the end of 4.60 that they were unsuccessful in that, partly because the court there decided that the statutory protections that exist in the English equivalent provisions in the Criminal Justice Act 2003 didn't exist here. So yeah, they were not successful, but they did apply to use that instead. Copies, I don't think we need to say anything about. Admissions, fairly self-explanatory. You make a permission if you want to take something off the table. It's not going to be contested or disputed thereafter. The case of Blondell and Butcher in 4.64, it's an entertaining case to have a look at. Apart from anything else, it's a cautionary tale about not taking things for granted. Everybody agreed, or seemed to have agreed, on the co-defendant's fingerprints appearing on a parcel of drugs that had been attached to the underside of the vehicle. Prosecution proceeded on the basis that everybody did agree that it was the co-defendant's fingerprint. Nobody said anything, as you can see at the top of page 88. Neither defence advocate at trial took any objection to that statement. Neither relied on the absence of evidence or admission, that's absence of admission, of the matter when addressing the deputy bailiff in support of an argument that there was no case to answer. Neither raised the matter when the deputy bailiff, having completed his summing up, asked whether they had any comment to make on it. Okay, all right, so that was it. Prosecution case was co-defendant's fingerprint was found on the tape that had attached this package of drugs to the underside of the car. Okay, before us, this is the Court of Appeal speaking here, Before us, however, the procurer felt bound to concede that no admission of fact in accordance with Section 2 had been made at the trial in relation to that being S's fingerprint, and then in the course of the hearing before us, felt constrained to accept that he could not support the conviction on the basis of proved connection between S and the package. Okay? So what we've got there is a situation where the prosecution felt, and you may feel with some grounds, that the defence had made an admission, effective admission, that the fingerprint that had been found on the tape attaching the package of drugs to the underside of the car belonged to Mr. S. Right? But nobody actually said, we accept that this is S's fingerprint on the tape. They never said anything about it at all. Okay, so that's why we finish up in the Court of Appeal with the prosecution bound to concede no omission of fact was made, and that was basically fatal to the conviction. The end. So yeah, so admissions can be made. If they are to be made, they should be made very explicitly, preferably, of course, in writing. They should normally be made in open court as well. I'm not going to talk you through this. It's quite an interesting case, but in 465 Fernandez from 2014, two defendants. One of them was married to a third party. The two defendants were allegedly having a sexual relationship, at the time, or around about the time of the offences. This is smuggling drugs into to the island, and Mr. Fernandez didn't want Mrs. Fernandez to discover this relationship had occurred at any point in time. So everybody got together, which is the prosecution defence got together and made an admission to that effect, and then put that in front of the judge. And the judge took that into consideration as part of the whole kind of sentencing process that was going on. But as you can see towards the end of 465, when Fernandez was sentenced, a recommendation for deportation was made, which he didn't like, and he appealed against that. And it then came out in the hearing of his appeal against the recommendation for deportation about this admission having been made, but not actually referred to explicitly by anybody in open court. And as you can see there, they said the spirit of Section 2, which is about making formal admissions, was that the subject ought to be referred to publicly in open court in the same way as the evidence would be that it's replacing. Yeah, sentencing is a public process in the course of which all persons having an interest, including the public, ought ordinarily to be aware of all of the evidence and arguments which are being placed before the court. So they basically said that sort of thing should not go on. Yeah, by all means make an admission, but don't try and keep that out of the public domain. However well-intentioned everybody was as far as that's concerned. All right, confessions. Obviously an important subject for us to think about. I think we all understand what a confession is. So 4.68, a provision I referred to fleetingly a few moments ago, Section 76 of the 2003 PPACE. Confession shall be excluded. It's so important to note the mandatory nature of this, shall be excluded, where the defendant alleges that it was obtained either by oppression or in consequence of anything said or done which is likely in circumstances existing at the time, to render unreliable any confession which might be made by him in consequence thereof, unless the prosecution can refute that allegation beyond a reasonable doubt. Whether it's true or not doesn't make any difference. Okay. So again, this is, I think, word for word identical to Section 76 of PACE, 1984 in England and Wales. So if you've never learned that, this is exactly the same. But oppression, again, standard definition, includes torture, inhuman or degrading treatment, use or threat of violence. Yeah, or in consequence of anything said or done. So in consequence of anything said or done, unreliability, very nice example of the court analysing that in the Correa decision that you can see referred to in 4.69, in a relatively recent one from 2016. Court has to ask itself, was there anything? What is it that's been said or done? Okay. For one thing, it has to be extraneous to the accused. So you can't kind of self-generate some issue about this. It has to be someone else saying or doing something. Second point, having identified what it is that is allegedly said or done, was that likely in circumstances to render any confession, which is why we don't care about the truth of this particular one, any confession in those circumstances unreliable? If the answer to that is yes, then we move on to the third point, causation. Did the thing which has been said or done actually cause the defendant to make that particular confession? Okay, so those are the three basic questions in that sequence that a court at first instance would have to consider in ruling on the admissibility of an alleged confession. And you can see that was applied in the De Kock case, 4.70. Although curiously there, the defence were more concerned about what hadn't been said, in the sense that Mr. De Kock, as I think we said yesterday, was being interviewed by somebody from HR and his manager at the bank. In regard, this was the yellow E-type Jag that Mark was talking about in that case. And Mr. De Kock was interviewed by basically two fellow employees at the bank. At no point did they suggest to him that he might like to obtain some legal advice or have a legal advisor attend. I don't know, he could have had a legal advisor attend, but yeah, whether he might want to adjourn the meeting with them in order to obtain legal advice, possibly about what to answer questions about or just whether to answer any questions at all. Okay? So it wasn't so much something said or done, it was something that should have been but was not said or done, i.e. telling him that he could get legal advice before participating in the interview. And there are all sorts of arguments in there about whether these two people were interviewers or investigators in the sense that they had certain statutory obligations placed on them or not.
One of them was also.
Yeah, and they'd also had quite a lot of contact with about money laundering and that sort of thing. Yeah, so I think it's fairly close to the line, in a number of respects. So it's quite an interesting case to have a look at. And it's specifically the 2016 one. What else do we need to think about? We can go over all of that. All right, so the other kind of key aspect that often crops up along with Section 76 and Section 78, so exclusion of unfair evidence, that's probably not the best way of describing it, but 4.74, the court has the power to exclude any prosecution evidence. So Section 76 is just about confession evidence. Section 78 is any prosecution evidence can be excluded if it seems that allowing that evidence to be produced at the trial, as it says, would have such an adverse effect on the fairness of the proceedings that the court should not admit it into evidence. Right? And that again is pretty much word for word rendition of Section 78 of PACE 1984 in England and Wales. It is said, I think that some people say that there is a discretion involved in this, because I think the wording is actually that the court may exclude, and you can see, I think I put that in footnote 391, the court may refuse to allow the evidence to be adduced. I don't think anybody understands that to be a discretion. You can see in 4.76 a reference to Blackstone's criminal practice, the opinion that no exercise of discretion is required despite the use of may refuse. Well, frankly, can you imagine, it's common sense, isn't it, really? Well, we find that allowing this evidence in would have such an adverse effect on the fairness of the proceedings that we should not allow it in, but what the heck is a discretion? So I'm allowing it in anyway. That's never going to happen, is it? So although it says may, the reality is once they find that it would have such an adverse effect on the fairness of the proceedings, it's going out. That's the end of that particular discussion. All right, much more in 478 and 479 about the De Kock case, which we're not going to consider further, but obviously it's a massively informative case to investigate. Character evidence at 4.80 and thereafter, again, can be quite important. Again, There is now a massive difference between courts in England and Wales and how they deal with defendants' character, because that's essentially what we're looking at here, defendants' character, and specifically bad character, how they deal with that, and how Guernsey courts deal with that. So, as it basically says in 4.80, the position in England and Wales, which up until 2003, I would say has been pretty much on a par with the position in Guernsey, suddenly went through a complete 180-degree turn, and almost all of the points about defendants' bad character that had been excluded for over a century from jurors hearing about, suddenly everybody went, well, actually, we can trust juries because they can be properly directed by the judge on how to handle this information. It's not that they're going to abuse it or anything, because they find out the defendant has a record, it's like done this 15 times before. They're not going to go, oh, he's done it 15 times before, therefore he must have done it this 16th time, or he's done some bad things on his record, he's a bad man. Yeah? Bad men need to be punished. He's guilty. The end. Yeah? They won't do that sort of thing. So we spent over 100 years worrying that they would do that sort of reasoning, that type of analysis. Yeah? And then suddenly in 2003, everybody went, do you know what? Jurors are intelligent people. Yeah? They won't think like that because we can direct them as judges, we can direct them, and they're responsible. They won't do that sort of thing. So in 2003, the law got changed in England and Wales. It's still as it was pre-2003 here in Guernsey. Yeah? Whether that tells us anything about the legislature or jurats, I know not. But it's just how it is.
It's in the pipeline, but
yeah. All right, so trying to keep it as short as I can in the time that we have got. Yeah, bad character evidence. As you can see at 4.82, bad character evidence. Well, let's go back to 481 actually, and the 1923 Loi. As a general proposition, accused is not to be asked questions which will tend to show that he has committed a crime other than the one he's currently on trial for, or to show that he's been convicted or even charged for other crimes, or that he has a bad character. This une fâcheuse réputation. So if he is asked such questions, he's not obliged to answer. And it follows implicitly, but I'm going to make it explicit, that the prosecution normally can't produce evidence to establish any of these things. So it's not just you can't ask them questions designed to show that, but you can't independently produce evidence to show that. But as it says, there are exceptions to that. So if it's necessary to produce evidence he's committed or been convicted of another offence in order to prove his guilt on the present charge. I don't know quite what firearms law is on in Guernsey, but certainly in England and Wales, possessing a firearm within 5 years of being released from a prison sentence, for example. Yeah. So in order to be shown to be guilty of the offence of possessing a firearm within 5 years of being released from prison, yeah, the evidence needs to show that on a date not more than 5 years ago, you were released from a prison sentence, yeah, which would be, quote, bad character evidence. But it's a necessary part of proving your case, so it has to come in. Okay. Alternatively, he sought to establish his own good character. I wouldn't do that. I'd never do a terrible thing like that. I'm just polishing up my halo as I speak to you. Yeah. So asserting his own good character, he's made imputations against the character of the complainant or other witnesses. You're a dirty, rotten liar. Yeah, you've always had it infamy in my family, etc., etc. Yeah.
Very difficult in practice. If you're accused of stealing something and somebody says they saw you steal it, short of calling them a liar, it's quite difficult.
It's a fine line to tread.
Mistaken.
Fine line to tread, yes. Can I suggest that you're mistaken? All right, okay. What else can we go on to? Similar fact evidence. Largely to do with cross-admissibility again. Yeah. So this would typically be a situation where it's a sexual offence, something like that. There's more than one victim, and their evidence is offered by the prosecution, at least, as each of them supports the other. Yeah? Because frankly, it's too much of a coincidence that people that don't know each other independently come forward and make pretty similar allegations against the same person. Yeah, what are the odds of that happening? Yeah, so that's what we're really looking at there in similar fact evidence. You've got, I think, a very nice example of it in the D case, which is referenced at 4.84. You can see there the Court of Appeal said the judge's direction was unimpeachable, and that's analysed from paragraph 35 of the judgment onwards. So I'm going to leave you guys to have a look at that. They also referenced the Dodd and Butler case. You see that carrying on at the top of page 94. Dodd and Butler was the one about the guy on the jet ski unobtrusively bringing drugs into Guernsey. It's great. You might as well have just had a big flag at the back of the jet ski going, drugs, anyone? No? Anyway, so that case is quite a nice example of similar fact evidence. Convictions as evidence of the commission of offence. So if the prosecution needs to prove that the defendant has previously committed another offence, a different offence from the one he's currently on trial for, then generally speaking, producing evidence of his conviction for that is a fairly painless way of ticking that box, if I can put it like that. I'm not going to take it at any greater length, given that it's now 4:01, but you can see there at 486, where proof of the defendant's conviction is put before the court, it raises a rebuttable presumption that the person has committed that other offence. And the exact wording is, he shall be taken to have committed that offence unless the contrary is proved. And who's got to prove the contrary? Him. So this is an example of a reverse burden. Yeah, it's an explicit or express reverse burden from when we were looking earlier at burden of proof. All right, some technical stuff in there. Expert evidence. I'm pretty happy that we've already thought as much as I want to this afternoon about expert evidence. Previously in chapter 2, special measures, we've already kind of talked about that. And given the time of day today, I don't really want to investigate that too much. What I would say is have a look at the Pinto case, which is referenced in footnote 411. Particularly interesting in terms of no common law right to physically confront the witness. This is another rape trial, obviously with multiple alleged rapists involved. The complainant, quite understandably, did not want to appear in court, did not want to see the defendants while she was testifying. So there was, if memory serves me correctly, use of a screen. But anyway, the key paragraphs I'd suggest you have a look at in the Pinto case would be paragraphs 8 to 9, paragraph 14, and paragraphs 18 to 21. Also, footnote 415, the Z case makes another appearance, that very sad case of the complainant who had the terminal cancer and died before the trial. So have a look at that in that context. 495, well, there are a lot of cases that would be helpful to look at. So 495, the case of D. As far as D is concerned, obviously that's a fairly recent case from 2018. I suggest looking at paragraphs 15 and 20 for that one. 496, the case of Z from 2016, again, in the context of paragraph 496, paragraph 13 of the judgment, and 13 and 14. We've then got the video recorded evidence ordinance of 2017, which is important, but I just don't have the time to go through it today. Important provisions about rape shields, so not dredging up complainant's sexual history unless the court gives permission to do that. That's at 4102. Cross-examining a complainant should not be done by defendant in person. The court may need to appoint special counsel to do that, whether the defendant wants it or not. Evidence can be given by a live link. That's dealt with at 4104. There is a section, which I think is the one that you were referring to earlier, Catherine, 4107,
Yes,
about reporting
it's
restrictions. Yeah.
It's actually very difficult to stop looking in Guernsey, and it's something if you practice defendants are always concerned about their privacy and their address, and they're going to lose their place because their landlord will check them out. And you have to be quite robust about it, unless there really is a risk to the administration of justice. So there are witnesses who might be interfered with or something like that. You're not going to get any sort of joy out of the court. And the court's made orders in the past to assist, and then being faced with injunctive relief by the press. So it's very difficult. There is also another provision about reporting restrictions in the children law, but that only applies to proceedings to which the children law applies.
Okay, and the last subject that we've got then is prosecution disclosure. And we've already touched on that a few moments ago, but Taylor and the Law Officers from 2011, I think, is probably the leading case still on that. And just so that you know, again, really, I kick off with the judgment there, in this context at least, from paragraph 127 through to 135, and then paragraphs 164, 165, and that will give you all of the material that I'm basically quoting from there. So paragraphs 127 through to 135, and then paragraphs 164 and 165. It is a balancing exercise in terms of disclosure of material that the prosecution has but doesn't propose to use. And the leading case is Crown versus H. And as I said at 4.112, although the court in Taylor said that that was the leading case, it didn't actually set out the expanded test in its judgment. And I thought it was helpful to set out the entirety of the test from Crown versus H. So English House of Lords test, those 7 points or 7 questions to consider there. They weren't all of them set out in the Taylor judgment, but as I say, the Taylor judgment did heavily endorse Crown versus H, so I thought it would just be helpful to have those in there. Right.
And don't forget, of course, it's an English test which is based in the jurisdiction where the defence has to disclose its case, whereas we don't, which is one of the reasons why Taylor calls it so important.
Yes, good. Well, thank you all. Thank you tremendously, Catherine. I think it's been a real boon having you here today. Tremendously helpful. Yeah, it's now nearly 10 past. So we've just knocked chapter 3 out as well? No. Okay. We'll stop there then. Good to see that you've retained your consciousness and sense of humour through to this point in time. So thank you all, and I'm sorry that we've gone over our time. We will stop there. Thank you. Well, I hope so. Yes. It's been tremendously helpful having you. Yeah, really tremendously helpful. Right. I'll be down in a couple of minutes.